Welcome and thank you for joining us for this epic adventure across the country. 24 hearings, 24 hours of content from last year that we probably missed the majority of. If you missed part 1 and 2, there are links in the description as well as timestamps so you can see what judge is on at what time. Today we are going to Fulton County to Judge McBurney to hear a quick hearing for someone who is suing the city of Fulton County, and then we are heading to the great state of Kansas for the fabulous Judge Phyllis Webster. Everyone have a fabulous day. And again, if there is any information that I should have censored out that I missed, please leave me a comment and make sure you tag me in it if I forget to pin the comment, but I will try really hard to remember. Things have just been crazy lately. Everyone, thank you so much, and let's go to court.
I double dog dare you.
Ma'am, you can't sue the baby.
This case is horrible.
The promiscuous defecation kind of speaks for itself.
Wrong.
Pardon me? You're ready? Great. All right. Well, let's get on the record. This is 24 CV 010646. Awa Best Braids versus the city of South Fulton. And I want to cover a few procedural things before we dive in, but why don't we start by getting the appearances. Let's start for petitioner / plaintiffs.
Your Honor, my name is Reno with the Institute for Justice.
Will you be the primary spokesperson today, or do we have a quartet?
No, it's me.
Okay, great. How do you pronounce your client's last name?
Awa Diagni.
That's all one last name?
Awa's her first name.
Okay, that's what I thought. So the last name you pronounce?
Diagni.
Diagni. Thank you. All right, and representing the city of South Fulton.
Your Honor, Dana Main, Freeman Mathis and Gary on behalf of South Fulton.
Ms. Main, thank you for being here. I know your colleague had a conflict today and asked that we do this on a different day, but if we didn't do it today, we were probably going to be meeting in December. And these are some pressing matters, so it was important that we meet today. I also recognize that you're playing catch up in part because your colleague may have been lead on this, but also because this is a relatively new matter. And so I'm well aware of that as we work through this, that there have been I won't say all sorts of, but there have been pleadings from, I'm going to say plaintiff. I know it's sort of a dual petition plaintiff, and you haven't had the full amount of time that you normally would to respond. I don't mean to put your client in a disadvantaged place because of that. We can start our discussion today, see how far we can get. If it becomes clear to me that you simply need more time to respond to questions or concerns I have, we'll certainly make that happen.
Thank you, Your Honor.
Sure. All right. So Ms. Flaherty, you cover the waterfront with what's been filed here. It's a petition for review. There was a decision by the city, as I understand it, and nothing I say you should take as etched in stone. I have tried to digest the record, and as I play it back, both sides should feel free to correct me before we dive into the substance of the dispute. So let me take a step back from that. In a nutshell, I understand the issue to be that Ms. Diagni wants to open. She already has a lease for a storefront in a shopping center in South Fulton where she wants to open a hair braiding business. And for whatever reason, she was told or believed she needed to get a special use permit. And one of the questions we need to work through is, do you even need that for the type of business that Ms. Diagni is trying to operate? Nonetheless, she tried to get one, and the first level review, check, perfect, we like it. And then it goes to the next level review. This is appropriate, let's do it. It gets to the city council, and lo and behold, there is a competitor who doesn't want competition. And there is an email campaign to one, it may have been multiple, but at least one, what I've seen from the record. And everything I'm sharing is in the record. It's not what's happening on South Fulton blogosphere. It's in the record, an email campaign led by Ms. Davis, who is the owner of, I'm going to call it Salon Vibes. And she and her customers and her employees really filled Council Member Willis's inbox with emails saying, you got to think about us and competition. I'm distilling it as competition could be problematic. And that's kind of the record. The vote is 4-3 to deny the special use permit in the face of the findings of the two lower bodies and without any factual findings made at all. 4-3, nope, you don't get it. So one reason we're here is what you styled as a petition for review. Judge, you need to review this if it was some form of zoning decision. Layered on top of that is a series of declaratory judgment actions that I think are being pushed through in terms of jurisdiction. Paragraph 5 of that amendment that was made to the state constitution, declaring that what happened was unconstitutional. Or if there is some, I don't know that there is, some ordinance that said too much competition is a basis to deny a license, that would be unconstitutional. I think the record is that there is no such ordinance, despite several council members either wishing there was or mistakenly believing there was. And then finally, failing all that, or on top of all that, injunctive relief, saying you asking me to enjoin the city of South Fulton from taking steps that would be plainly harmful to another set of dreams, the dreams of Ms. Diogni to have her business. That dream shouldn't be viewed as any lesser importance than Salon Vibes dreams, and let her pursue her business. And if that is something that creates competition, you know what? We can't stop Burger King from opening across the street from McDonald's. And I'm not making any ruling. This is just sort of the thrust of the argument as I've read it from you. Is that sort of a fair summary of plaintiff's position?
Yes, Your Honor.
Okay.
That's all exactly right. And as to whether she needs a special use permit at all, they're categorizing her as a beauty salon. You know, for what it's worth, she's a braiding shop and not a beauty salon, but that's the city's position, and I'll let Ms. Fulton speak to that.
Well, we'll talk about that. I have a set of issues that I want to understand from both sides. So we have some funky procedural things we need to work through that are set forth in, I remember if it was the emergency motion, where there's an acknowledgement that, well, you can't really get an injunction when you're seeking declaratory relief through paragraph 5, but you can get an injunction in this other space, and maybe it's not precluded. And so I'm happy to wrestle with that. But where I really wanted to start with you, and then hear from Ms. Main, and then I'll let you move forward from plaintiff side, and then we'll obviously hear from the defendant side. Why is the solution to this not simply, it's a petition for review, it's reversed, there is no basis for denying, there's no record, it was simply denied, and you can't simply get a red stamp that says denied, hit that on a piece of paper and deny it. There have to be findings of fact. In an absence of finding of fact, it is by definition arbitrary and capricious. Denied, you need to grant it, because the only record would be the two lower judicatories saying, yes, it should be approved. And then there's dialogue at the council meeting, and there's the email campaign, but there's not what's required under the ordinance of a finding of fact or findings of fact. So we've got instead 4 council members saying no, but not doing what they're obligated by their own laws to do, giving the reviewing court nothing to review. And so the same argument could be made if it was 4-3 to approve, and someone who was unhappy with the approval said that's as arbitrary approval, there are no findings of fact. Maybe one could argue it was simply they adopted the findings of fact of the two bodies had already said, look, it meets all the requirements, and so it ought to go forward. So that's where I want to start, and then you can go where you want to go from there.
If I understood your question, Your Honor, is if the court ruled that way, would it,
Why shouldn't I rule that way, and why shouldn't that be it, full stop, and not worry about a declaratory judgment or an injunction? That's sort of the simplest, but it's the one that hits you in the face, hit me in the face as I'm reading through this, is that, and city council people aren't lawyers. I mean, they can be. I don't know that these are. And they are putting the interests of their constituents foremost, which is what they should do. But if it wasn't done the right way and there's nothing to review, I'm just wondering why that's not the way to handle this.
I think that sounds great to me, Your Honor, so long as the reversal involved granting her the permit and her being able to open her shop, that would be great, and that would move everything else.
Do I have the authority to say you must grant it, or do I only have the authority to say, how could I possibly rule on this? You didn't give me any findings of fact.
So Your Honor could reverse with instructions, and that comes from Georgia Code 5-3-18A. Your Honor can affirm, vacate, or reverse, and reverse with instructions. And I think the court could reverse with instructions to issue the special use permit.
Okay. All right. Assuming that's not what happens, where do you want to go next? Wait, before we do that, Ms. Main, I want to make sure that before Ms. Flaherty dives into here's other reasons why you should grant our petition for review or the deck action, et cetera. If any of the things I've described struck you as this is not what the record says, let's clear that up now so I'm not laboring under any real bad misapprehension of sort of how we got to be where we are today.
Your Honor, it's a loaded question. There are some factual issues in terms of findings of fact that we disagree with that I'm happy to go into with the court.
Mm-hmm.
But sort of getting back to let me go back to the beginning. I believe what the court led with in terms of what we can do here, we're here under a petition for review. I believe that we should stop there. And we get to the same place. And Your Honor, that is one of the reasons why I'm not displeased that I had to stand in Mr. Klein's shoes today, because I do want to bring this to a conclusion one way or another. And I believe that the court can do that with the petition for review. And I believe that that is the appropriate and the only route for the court to take.
Okay. Well, why don't we stay focused on that, at least initially, when I hear back from Ms. Flaherty. But tell me what you think I was either I hadn't found yet in looking through the record or had misapprehended. It wasn't meant to be a loaded question. I try to start hearings by saying, I think this is what's going on, and then ask for that immediate feedback so it doesn't cement into place, because if the way I think things are, what the record shows is favorable to the side that goes first, they just, great, don't change your mind on that. And I haven't decided anything yet.
Yeah, yes, Your Honor. In terms of a couple things about the in writing, first of all, I mean, it's not required to be in writing, the findings of fact.
Mm-hmm.
And we would submit the findings of fact. There are findings of fact that were in the two recommending bodies. They're not, they don't go up by appeal. They're just, staff makes a recommendation and then the planning commission makes a recommendation. And
right.
Both of those had findings of fact.
Yeah.
And then the city, but they don't consider everything and they're not in the same position.
Who doesn't consider everything? The staff and the planning commission?
Yes, sir.
Okay.
Yes, Your Honor. And so then the city council and the council members are in a different position than the other two bodies are. And Your Honor, we did a supplemental filing in terms of the record at the request of the plaintiffs.
And Ms. Niles flagged that, and I think it's in my my folder right here. So.
And there, Your Honor, you're not going to find a findings of fact in that supplement.
Okay.
Your Honor, I did, and I don't know if it's gotten filed or where it is. We've got the comprehensive plan, which is got the zoning ordinance. The comprehensive plan is adopted through the zoning ordinance, and then through that, you've got a document, sorry, Your Honor.
And I know that's one of the standards. In fact, that's standard number one. Is the proposal consistent with the comprehensive plan? It's capitalized, so it must be an important plan. But I bet the comprehensive plan doesn't say stamp out competition.
It absolutely does not say stamp out competition, but it is in the opposite. And so, Your Honor, I know that is how the stamp out competition, I know that that's how it's been framed.
Right.
But the fact is that the issue is a concentration of uses. In the comprehensive plan, and I've got copies that I can give the court, and also they are in the process of being filed. They're large documents, so there's some difficulty my office doing it. There is an economic development strategic plan that was adopted as part of the comprehensive plan.
So I think I don't know that I have it. I have a 207-page filing that came today. Would that have what you're holding in your hands?
It does not. That's the zoning ordinance, and then these are two that the zoning ordinance adopts the comp plan, and the comp plan is part of this economic development test or study that's done.
Okay.
And the council member who spoke and Your Honor, I believe that the video, did we successfully file, if we successfully filed the videos?
A placeholder for it, so
Were they not?
that I don't know.
Okay. Your Honor, I think we need to, for the court's purpose, both of the planning commission and the city council meeting were videoed. And
There's page 54 of the record says YouTube link placeholder for video recording of the July 9th and July 23rd meetings. So I don't know if that's a link I can click on for later consumption or how that'll work, but that's one way South Fulton makes a record is that it, okay.
Yes, Your Honor. And if we could with the court, if the court doesn't make a ruling from the bench today.
I'm not making a ruling from the bench today.
Thank you, Your Honor. If we could, then we'll come to an agreement with the court about what format, but we have referenced to the court. It was on Councilwoman Willis, who was the one who made the comments about the concentration of uses and the economic development purpose behind not wanting to have a concentration of uses. And this one shopping center has a beauty supply store, and it has a beauty shop, and then it has what we maintain, the hair braiding is a subset of the beauty shop. Beauty shop does hair braiding, and but the plaintiff in this case does just hair braiding and not the full services.
Mhm.
But Your Honor, and Councilwoman Willis was intimately involved with coming up with a comprehensive plan, voting on it, and involved in all of the meetings. And as she says on what we consider to be the record, that they have been working very, very hard since the city was established to have a diversity of retail, and that this concentration of uses goes against their attempt at creating the diversity. And Your Honor, we have cited in our brief, we had cited to different pages in those two documents that refer to that concept.
The two documents meaning the two YouTubes, or the two documents meaning the comprehensive plan?
Well, Your Honor, both.
Okay.
We cite to where it is in the transcript, or not transcript, where it is in the video and at both meetings. And then we also cite to where it is in the comprehensive plan and in the economic the Economic Development Strategic Plan.
Those are two different things.
Yes, Your Honor, and it's that the zoning ordinance it references and adopts the comprehensive plan, which which has as part of it the Economic Development Strategic Plan. And all of these were done at the beginning when the city was being formed. So Councilwoman Willis explains how they've been working. They inherited from Fulton County what she considers to be somewhat of a mess in terms of creating a vibrant society with a mix of retail uses. And that is what she said, all that citizens have been asking for it, and that has been a problem. And again, it's cited in these documents that were the strategic plan was finalized in June of 20, and the comprehensive plan was finalized in November of 21. So these predate the plaintiff's petition in this case.
Sure.
And so
You would have to, because I shouldn't have to, but almost everything ought to predate this application. This all happened very recently.
yes, Your Honor.
And it would be particularly problematic if this notion of we want to avoid economic saturation came up only after the application. I assume everything that Councilmember Willis is pointing to would be things that were some of the genesis of the city of South Fulton, which itself is fairly young.
Yes, Your Honor, it's very, very new.
Okay.
So, Your Honor, those are from what the court had said, that is.
But how do I figure out what the decisions rely, well, let me put it differently. Per the city's own ordinances, this is 80403. Following the public hearing, there were two of those. The city shall adopt findings of fact. How do I know what was adopted? And is it just whatever side wins the vote, the record becomes findings of fact? And if that's findings of fact, if a city council member, all I need to do is give me the microphone and I'll create a great record. That doesn't mean it's fact. And it doesn't mean anyone found that fact. I just happen to be on the winning side. So I'm struggling a little bit to, that phrase findings of fact means something to you, given what you practice and where you practice. And it doesn't typically mean see everything because presumably there were voices of the three who voted in favor of this application that could also be findings of fact, maybe not of the majority, but I don't know. So I'm not sure what you're pointing me towards as what would constitute the findings of fact.
Your Honor, there are a couple of responses to that as immediate. I mean, I've been doing land use for several years.
Mhm.
And for special use permits or conditional use permits, there is no requirement in case law or in statute that you have findings of fact. And in fact, I have never worked with an ordinance that included that phrase.
But this one does.
But this one does, but it is not. So if we were here today, we would be doing, I mean, we were with an ordinance like the others I've been using for 30 years. Those don't, they may exist out there, but this is the first one I've ever had. What you do is the facts are in the record. And yes, Your Honor, I will go to the record and look for facts that support either the approval or the denial, whichever one is being challenged. And Your Honor, there are findings of fact that were written by the staff originally, and then those went up. The staff in terms of, there was not any disagreement. The staff with reference to the comprehensive plan said, and it had to do with, Your Honor, comprehensive plan or economic plans, that one they said they didn't know, or that they might have answered a no to that, Your Honor. I'm sorry for. Your Honor, in the record, it's on the records on page 45 of the staff report. It says number 2, is the proposed use consistent with the supplemental plans adopted by the city council, such as revitalization or economic development plans? And the answer is not to staff's knowledge. So, Your Honor, that is a finding of fact of sorts, but Your Honor, with which it does not appear the city council would have a disagreement. But Your Honor, yes, we would go back to the statements that Councilmember Willis made at both the hearing, the original hearing, and then at the hearing or at the meeting where she voted. They all voted.
Is this shopping center in District 3?
Yes, Your Honor.
Okay. Other things you wanted to help me understand about maybe the structure of the process in South Fulton. This was helpful to learn, one, that this notion of findings of fact is kind of new and different for you. I need to explain to folks, I'm presiding today for another judge. And so Deputy Gordon may from time to time appear saying, hey, could you sign something? And we'll pause what we're doing so I can do that. But were there other things that you thought I ought to understand about the kind of process flow of this getting from application for special use permit all the way to the city council's 4-3 vote?
I don't believe so at this
denying.
point.
Okay. All right. Then let me turn back after we do this. Hold on 1 second. All right. Ms. Flaherty, whenever you're ready.
Absolutely, Your Honor.
Thanks.
First of all, I agree with Your Honor that there don't seem to be any findings of fact that the city council enacted, and they were supposed to do that. But to the extent that they adopted the zoning staff's findings of fact, then we would still win, and Your Honor should still reverse the decision, because then there's insufficient evidence in the record that the city did this for any reason but protectionism.
What about Ms. Main's point that a council person is saying things on the record and saying, I find that this license if issued, would be inconsistent with the economic development strategic plan? That's part of the record. It's not something that I might normally view as findings of fact, but the city made its own bed, and its own ordinance says you'll issue findings of fact. You will adopt. It doesn't say issue, it says adopt, but they'll adopt findings of fact. And so maybe when they voted 4-3, they're adopting the record that was made, which problematically, I think, for the city includes the findings of fact of the staff and of the planning commission. But to Ms. Main's point, wouldn't it also include whatever record was made that I would gather by watching the 2 YouTube recordings?
Ultimately, Your Honor, I don't think that matters, because taken all together, the record is still completely insufficient and still requires reversal. And
what's insufficient about, and I haven't watched it yet, I'm relying on Ms. Main here saying that Councilmember Willis may have provided some pretty insightful commentary on, we are trying to build a city that allows for growth in many places and doesn't end up with all the fast food restaurants on fast food row and all the liquor stores on liquor row. And it is spread out so that if you're in one part of town, you can knock out 4 errands rather than having to go way over here to get your hair done and then 4 miles over there to get your tires changed. Assuming something like that is in the record, why wouldn't that be, given what my review is, if this is a petition for review, that might not seem super compelling to you, but that's not the test, whether Ms. Flaherty was overwhelmed by the analysis. It would be, there's a reason that's not arbitrary, that we are seeking to smooth out the presence of different forms of retail throughout the appropriately zoned. So we're not going to put a gas station in the middle of cul-de-sac, but just sort of smooth it out around the city of South Fulton.
2 responses to that, Your Honor. I think that economic development is just sort of another way to say protectionism is just sort of a fig leaf here. But even if it weren't, economic development is not a legitimate health and safety reason for zoning. Zoning is more like, don't put the gas station in the cul-de-sac, don't put the chemical plant next to the elementary school. And the one thing Your Honor didn't mention at the beginning was the case Raffensperger versus Jackson. And that's just last year, the Supreme Court of Georgia said that protectionism is not a legitimate reason to interfere with someone's right to earn a living in the occupation of their choice. And not only did the court say that, but they said that if there is a different reason, it has to be a legitimate health and safety reason. And the government's action has to be reasonably necessary to further that legitimate interest. And that's absolutely not what we have here. Just some sort of broad economic development rationale is not a real health and safety reason to interfere with always very, very important right to earn a living in an occupation of choice.
Okay. What else do you want to tell me about granting the petition for review?
The only thing I can think of, Your Honor, is that the links to the videos are also in our briefs. If the record is a little bit cumbersome.
I mean, it's not, I just need there's the link so I can cut it and paste it, and presumably I don't need a secret South Fulton code to get in. It's
Oh, no,
public
publicly available on YouTube.
for all late night viewers.
Exactly.
All right.
Password.
YouTube is a powerful space, I can tell you. Let me see if I had other questions. Do I even need to tangle with the question of whether a special use permit was required? Or should I just take head on, you know what, we did one anyway, and the issue here is that it was improperly denied? As opposed to saying, Ms. Diogni shouldn't have been put through the special, it sounds like she put herself through it, but I don't know the origins. I don't want you to get into things that aren't in the record. If she said, I'm opening, and then the ordinance police showed up and said, you can't open without a special use permit. And instead of saying, well, wait, look, I don't use chemicals or whatever would trigger the special use permit requirement. She said, okay, I want this to go smoothly. Tell me what I need to apply for, and I'll do it.
Well, I don't think any of that is in the record.
Okay.
Insofar as we do have an equal protection claim in our
Mhm.
deck action that says that she shouldn't have had to get a special use permit because there are comparable businesses that don't.
Right. I think that's a great argument if we have to get over in that space. But it's not in the record as to why she applied for a special use permit.
That's correct.
Okay. All right. And we won't tangle with that. Okay. Those were the questions I had for you in that space. So why don't I turn to Ms. Main, and then it maybe that's where we stop for now. And it may be that we have a conversation a bit about the declaratory judgment or the injunctive relief part. I will very much want to get input from both sides about whatever's happening next, given that for the very same reason people are passionate about ensuring that Salon Vibes prospers. We have someone who has invested money and has potential employees who want to get started and is stymied right now. So I think time is of the essence for everyone. Not ruling from the bench, like I said, but I'll very much want to understand if we think what's next is X, what's the time frame? And one reason why I'm flagging that is it's not this case, but I often have a situation where someone says, oh, sure, we'll send it back to the city, but they don't meet on zoning matters again until April. And that's not how we would need this to work, because then it would be sent back in a different way. But Ms. Main, tell me your thoughts, because you said, I think you're right. We need to handle this just through the petition for review angle.
I do think that that is the only thing that the court can do. I don't think that there is jurisdiction to do anything else. We have an adequate remedy at law. That's what we're doing here. I will also point out, Your Honor, that to the extent that there is a constitutional challenge, there was a constitutional letter that was sent to the city, but in footnote 1 of that letter, it says,
What's a constitutional letter?
Your Honor, in order to bring a constitutional challenge to this court, that challenge has to have been lodged below when you're up on a petition for review.
Oh,
So you had to have made a constitutional challenge, the applicant does. There is a letter that sets out, it's from what is now plaintiff's counsel, a letter that sets out some concerns, but in in footnote 1, they admit that they're not representing Ms. Awa. And so it says, we just learned of this matter late last week and do not currently represent Awa. So Your Honor, so the concept of this court being able to rule on a constitutional matter, it cannot. I don't think the court needs to rule on a constitutional matter. In fact, there is the first petition for review would get the plaintiffs to where they want to go in that direction if that's what the court rules. And so I don't think that there is any harm one way or another, but the fact is that the applicant herself, and we've got, and Your Honor, we did not raise this issue, but we've got an individual and then we've got a company. And for purposes of what we're doing here today, again, to expedite the resolution of this matter, we have not gone into that. But one of them does not have standing, Your Honor, but that's not relevant at
okay.
this point.
But appreciate you flagging that because I noticed we've got both here. So either way.
Yeah, Your Honor, and that, again, we like the plaintiffs would like to have a resolution, and an expedient resolution one way or another.
Okay.
With this matter. So, Your Honor, but that's why in terms of what's in the record is significant, and the decisions that can be made through the petition for review are before this court. Your Honor, we had filed a responsive brief earlier today, and we do address Raffensperger as pointing out that it has to do with the regulation of a class of occupation. And that is not, no one in the city zoning ordinance does not say you can't be here. City zoning ordinances all the time have separation requirements. They have.
What's a separation requirement?
If you've got a liquor store, you can't have another liquor store for 500 feet or 500 yards. You can't have a liquor store here. You can't have a liquor store near a church. You can't have, there are other uses that they say you can have a separation requirement for fast food restaurants. You can have separation requirements for gas stations. You can have separate. So, Your Honor, and one may say, oh, that's not fair. The city likes Quick Trips and they don't like Exxon. Your Honor, and
So there's case law that would support the validity of separation requirements.
yes,
That's in your brief?
that is not in our brief. I will get that to you today.
That would be great. But that's what that separation requirement doesn't mean when you're firing someone from the city government. It is exactly what you said, that only one liquor store every 3 blocks on the main thoroughfare.
Yes,
And that can apply to sin tax businesses like fast foods, or I don't mean to suggest they're saintly, but I know there is funky zoning about you can't have insurrection near a school, and that would make sense for liquor store. When you're dealing with hair braiding, that would seem like it is interfering more economically and less of we don't want a liquor store right next to the high school. I get that.
But Your Honor, the separation in this isn't, and it is a special use permit process. And the special use permit process says, we know there are some uses that are going to be appropriate in these districts, and sometimes they're not going to be appropriate. And what went into, now I can't, and it's not in the record, I can't tell you why the city had had special use permit for this particular use, but there is no doubt that they have, it is a special use permit that says when it comes up in front of us, we are going to look at it on a case-by-case basis. The concept of a special use permit is well recognized in law. It's in the CPL, it's in case law. There is no issue about a special use permit.
No, I didn't hear plaintiff saying the idea of a special use permit is a bad thing. There is a question of whether Ms. Diagni needed one, but that's not before me because she applied for one. I guess she could try opening up saying, I don't have to have one. And that's a different challenge and see what happens there. But she tried to follow the procedure that someone told her she should follow. So I'm not pushing back on the idea of the special use permit. It doesn't jump out in reading about the factors to be considered that separation is one of the factors, other than that they're generic or exceedingly broad things like, is it consistent with the comprehensive plan? But that could be a great catch-all if the comprehensive plan focuses on the value to the South Fulton community of avoiding concentration. I don't know.
Yeah, yes, Your Honor, but avoiding concentration is, I mean, every time you have a special use permit, you're going on a qualitative analysis of that use in that location and the factors that go into that, Your Honor. And I certainly, you know, you have, and I know hair braiding is not like this, but the example that I have dealt with the most are rock quarries. Sometimes they're going to be in a place that's appropriate and sometimes they're not. And sometimes you're going to be up against Vulcan and sometimes you're not. And so each time there is a qualitative analysis that goes into each location. So, Your Honor, and that is what happened.
Qualitative sounds like a euphemism for subjective.
I understand why the court believes that there is, I mean, there's going to be some subjectivity to that analysis. There has to be, because that's the concept of a special use permit. Otherwise, you don't, I mean, if it weren't allowed to be subjective, you wouldn't be allowed to have it, because that's the whole point.
Because there'd be nothing special. It would be automatic. If you check these boxes, we have to give you it. You can open up your
Yes,
business.
right. And this is a mechanism that allows the city council to make that decision. And Your Honor, am I thrilled that I have the Planning Commission recommending approval and I'm defending against it? No, I would much rather have it the other way. But does it happen this way? Yes.
All the time.
It does all the time, because the elected officials are in a different position. They have gone through their role is completely different, and their education and their training in terms of the city development and the stewardship that the city council has is different than the planning commission has.
They can't afford, if they want to keep their jobs, to be as objective as the planning commission can.
Your Honor, that's not their, again, it's not their role. Their role has to be subjective. And the other.
Well, I mean, they're the ones who would decide what the standards are, and then they have an entity that says, does this comply with the standards? Yes, that ought to really be all there is, but there is necessarily a subjective gloss that gets put on it through the hurly-burly of the politics, and that's what we have here. I don't think it's more complicated than that, but I also don't know that that's wrong. I'm not saying that that's fatal to the outcome that happened here.
Because otherwise we would just stop at the planning commission, and the planning commission would be the ones to make the final decision. Which
has a lot to be said for it, but it opens it up to scenarios like this, and that's the system that we built. I'm not just that's where we are. I don't know that we need to be as euphemistic about it, but it is what it is.
Thank you, Your Honor. That's all I have at the moment.
Okay. So, Ms. Flaherty, to me, that was a persuasive distinguishing of Raffensperger. Do you want to try to get Raffensperger back on track? Raffensperger is a great case for some of your argument, but I was on the wrong axis as I was looking at it. I'm confident, having had cases with Ms. Main before, that she will send you and me a bunch of cases that the Court of Appeals or the Supreme Court say separation requirements are okay, exercises of local legislative authority to say you can only have one gas station every 0.5 miles on a street or this or that. And that seems to be the logic behind what was articulated by some of the council members who decided to decline or deny the application. That seems to collide a little bit in an unhelpful way for you with Raffensperger.
Certainly, Your Honor. I'll address those cases first and then Raffensperger.
Okay, I don't have those cases in front of me, so you're not going to be distinguishing a whole lot other than the concept that those cases represent.
Sure. Those cases aren't applicable because we don't have that ordinance here. We don't have that general separation requirement. We've got the city council acting against a single person in a protectionist way. And there could be, if there was an ordinance, there could be a legitimate health and safety reason behind that, which would still have to pass muster under Raffensperger. And what Ms. Main seemed to be arguing was that Raffensperger just doesn't apply to zoning. And I don't think that's the case at all, because it spoke very broadly about the right, the constitutional right that's at stake, and that's the right to earn a living in the occupation of your choice. And the government might interfere with that right through an occupational license. It might interfere with it through zoning. It doesn't matter what the government is doing. It just matters what the right is at stake. The right is at stake.
If there's a health or safety justification like licensing, we want to make sure when you are tweezing eyebrows, you don't stab someone in the eye, so you have to have certain qualifications. That type of interference, it's not the word I would use. I'd view that as good regulation, but that's something, that burden that it would place on the business owner is something that wouldn't be inconsistent with due process.
Absolutely.
Okay, but if it's more economic based, saying it's not great for the Jack in the Box to have the McDonald's nearby, that's more Jack in the Box's problem than the public saying it would be unsafe to have so much beef in the same 400 square feet.
Exactly, Your Honor. And the Georgia Supreme Court was clear about that protectionism is not a legitimate interest. And I think one of the cases that they cited is instructive, the Moultrie Milkshed versus Cairo case. And that, while it wasn't about zoning, it was about a geographic restriction on doing business. It was about a milk plant not being able to, only being able to sell their milk locally. And so it was meant to protect local businesses from competition. And the court said that there was no health and safety reason for that, and so it was illegitimate. And Raffensperger relied on that, and that's obviously not an occupational license.
Does there have to be an ordinance in place that imposes separation requirements? If there are cases in Georgia law that have upheld the passage and implementation of separation requirements in a zoning framework in a municipality, then that says to me that the courts have said, there are some non-health and safety rationales that could prevent a business from opening exactly where it wants to because it's too close to another business of the same type. And so if such an ordinance can be passed and it would be lawful, why can't that just be the policy, informal though it may be, of a council member or a council majority?
If those cases exist, Your Honor, Raffensperger overruled them. And here, the city doesn't have that process in place, and there's not that general ordinance. And so, since they're not doing it that way, that in itself doesn't conform to the process.
Okay. Did you have any thoughts about the findings of fact being, hey, whatever was in the record during these two meetings, as opposed to and it's a fairly crabbed perspective I have, but I envision it has come up recently in cases that we have had in Fulton County involving a different municipality, a much larger one, where the municipality is trying to make someone pay a very large water bill. And there is an appeals process municipally, and ultimately there's something, I'm gonna get the name wrong, but the Water Bill Review Board. And ultimately they say you have to pay the bill. And if you don't like that ruling, it gets appealed to Superior Court. And that has to include findings of fact when they say, here's why you have to approve, why you have to pay the water bill. And it's a report. It's actually something that they have to sign off on. That's not what the ordinance here in South Fulton says, but it just seems a little squirrely to say you can adopt sort of the aura of the findings of fact from the meeting. How is that meaningfully reviewed? I'm sort of making your argument for you, but what is your perspective as to what I may properly rely on in assessing whether there was a factual basis for the denial?
I agree completely, Your Honor, that they haven't made your life easy here and that.
But that's not the standard. That was the standard. Lots of cases would go away.
Certainly, Your Honor. And this petition for review process is new and perhaps there's not a lot of case law on what the standard exactly is, but I think it's notable that the city's own ordinances say they have to do this and they should be held accountable for that.
Okay. Ms. Main, Raffensperger overruled the separation requirements cases. My guess is you disagree with that.
Your Honor, I have not looked at that case with that eye. And so I'm not, I would like to look at it and disagree with it, but I'm not going to say to the court that, and I think you need to do more than what we're talking about with the case to overrule a whole line of cases, but I would like the opportunity to look.
Okay. Well, I'm guessing, just given, again, where you practice, there's not a footnote in Raffensperger that says, and by the way, all those cases that talked about separation requirements, we hereby overrule them. This would be, if it is, it would be an overruling by implication. If we take the Raffensperger, that's a complicated name to use in connection with this because of all the election stuff. But that case, it sets forth a certain principle, and maybe it's fatal to the separation requirements line of cases. Maybe it's not. You help me appreciate that they aren't head on anyway. There's one that says you can't apply this trade in this community, bless you. And that's not what a separation requirement says. You can do hair braiding, just 2 shopping centers over. Don't do it right here.
Yes, Your Honor. And she can still do hair braiding. So, Your Honor.
In South Fulton.
In South Fulton.
Just not in maybe District 3 or that part of District 3.
All I know is not at the location that she applied for, Your Honor. I can't go any further than that. But I also did want to point out 2 things to the court. In the zoning ordinance, and it's in the very first section, it's 103, talks about the purpose.
All right, hold on one sec, because I just have little snippets. Is the zoning ordinance?
It's on the record, page 84.
Okay, the record, this is what you filed today?
I believe this part was filed today. There are 2 different parts of the record, and we filed
supplemental record.
I believe that this was part of the supplemental.
Oh, yes, look, here we go. Oh, and is this the constitutional letter you're talking about? Number 9, item 9?
Your Honor.
Where they capitalize the mayor's name.
It's at the very end. It is on record page 253.
Yeah, that's what you're referring to as the constitutional,
Yes,
right?
yes, Your
Okay. All right, but you're saying page 84.
84 at the very top of that is what we've been talking about, and there.
Designated uses?
No, Your Honor, it is the very top, and it just talks about the purpose of zoning, and I just point out.
Okay, hold on one sec. Let me get to it. I had to subtract like 50 something to get to the actual number. 84 comprehensive plan, 103.02.
It's right above that, Your Honor. It's actually starts on the previous.
Oh, purpose, section 103.
Yes, Your Honor. And because we've been saying health and safety, Your Honor, the purpose of the zoning ordinance, there's no problem with this, but the purpose of the zoning ordinance is broader than health and safety.
Prosperity.
Prosperity and general welfare of the city. For facilitating the development of the city in harmony with the comprehensive plan of the city and for purposes described in that's. But Your Honor, so the zoning ordinance itself is more than health and safety. So Your Honor, that is why this from the city council's perspective, why they would be allowed to do that. Your Honor, I also would like to point the court to just one more element, and it has to do in the staff analysis. Your Honor, there is, and this is at page 51. There is a study, and this is before it goes to the planning commission.
This is page 51 of the record.
Yes, Your Honor. And it says page 9 of 11 in the staff report. And Your Honor, that is
Page 51 of the record. What I've got is it's a picture of 5370 Campbellton Fairburn Road.
Yes, Your Honor, that is the correct page.
Oh.
That is the address of where the salon, the SUP had been. Your Honor, that is a study of all of the other uses that are the similar use in a 1 mile radius. And Your Honor, that was created by staff before it ever went to planning commission and before it ever went to city council. And I only raise that to say that this is not a made up after the fact, let's justify and be protective as to this one salon. Your Honor, this analysis was done by staff to be able to be presented to the city council. So it is an issue that was not made up to protect an existing facility.
When you say issue, though, apparently neither the staff nor the planning commission thought it was an issue. It's data, but that data wasn't something that gave them heartburn. They said,
Yes, Your Honor, that you're correct.
Okay.
And the city council makes its own decision.
they do, they look at the data and they get input from the community in a way that I guess the staff and does the planning commission, is that a situation, if it's in the record, do they have hearings?
Yes, Your Honor.
Okay, so that is just as open to people sharing their thoughts.
Yes, Your Honor.
Okay.
Yes, Your Honor.
So I don't misinterpret page 51 of the record. There's a big blue circle with let me do this. All right, on your screen or in front of you, however you want to do it, is page 51.
Yes, Your
So there's
Honor.
a big blue circle, which is what?
The mile radius.
From that point. So 5370 Campbellton Fairburn Road, a 1 mile radius from there.
Yes, Your Honor.
And that's basically the shopping center we're talking about.
Yes, Your Honor.
So within 1 mile, and then there are these colored dots that are right next to what looks like the center of the circle. But those colored dots aren't looks like there are 4 salons listed.
Yes, Your Honor, and it's not clear to me if they're all located, if those dots are all located in the area.
Okay.
So I can only go by in terms of the record.
Got
I
it.
can only go by the narrative that's underneath that shows the 4.
Within 1 mile, excuse me, of that stake in the ground, obviously Salon Vibes, it's in the same shopping center. There is something listed as a barber shop, Presidential Cuts,
Yes.
a nail salon, so not really the same thing, and then a beauty salon, Styles by LASIN. They didn't seem to be, I guess, quite as concerned about the braiding shop coming in. Maybe there's something in the record, but I only saw things, comments relating to Salon Vibes.
And Your Honor, I don't know whether the other locations, if they had people, they're limited to 10 minutes per side. And so sometimes if there are people who are there, they won't necessarily, I mean, we can't read into that they're in favor of it or not. And I
No.
don't think that there's anything in the record one way or another about those other locations.
Well, what's not in the record is emails from these places. Somehow they're emails from Salon Vibes. I don't know how they got into it, but they're there.
Yes, Your Honor.
So one can read into the record that Styles by Layson didn't send emails in because they're not in the record.
That's as far as I know. Your Honor.
Okay, all right. And at the bottom, it says meeting on June 26th. So that would be the meeting of the Planning Commission.
Yes, Your
It
Honor.
was done in preparation by the staff for the Planning Commission meeting of June 26th.
Yes, Your Honor.
Got it. Okay. Thank you. Take that down. Let's pause for a second. So, Ms. Main, what is it that you think we do next? You find some separation requirement cases, I know that, but what is your proposal? It's you should affirm the city council because, or send it back for written findings of fact, or what? I know the relief that Ms. Diagni is seeking, and I have very much understood your helpful explanations of how this was working and the city's perspective. But what's your bottom line? Because you were reassuring that, look, we can work this out. That's not the words you use, but the way to address this is through the petition for review. We ought not, and maybe aren't able to, for legal or procedural reasons, to get to the declaratory judgment pieces or the injunctive relief.
Yes, Your Honor. I believe that the court can follow pursuant to the petition for review, can do one of the elements in there. And I would ask that the court either dismiss the appeal, which would let the denial stand, or send it back if the court is concerned about the element of the factual findings, that the court send that back to the city council for those findings.
So dismissing the appeal would mean affirm the city council action?
Yes, Your Honor.
Okay, and that's because what you've pointed out in your reply or your response, I haven't had a chance to read that yet, came in today, but you've been articulating some of it in person, that there was a factual basis for it, that the a concept of a separation requirement and city council members taking in consideration the economic impact of high density of certain retail locations, that's all appropriate. You're not limited only to thinking about health and safety, and that's not the only justification for saying no to a request, et cetera. That taking all that in sum, and the standard of review that I'm to apply in a petition for review of a zoning decision gets one to the point where the correct legal response is to say, basically affirmed to the city council, which would be dismissed to the petition.
Yes, Your Honor, because it's any evidence in the record, and it is admittedly a low threshold for the city to overcome. And it's any evidence in the record, and we believe that there is more than any evidence in the record.
All right. How long are the two YouTubes?
Your Honor,
Well, it's probably the whole meeting.
no, they're painfully long for the court to, one of them I think is even like 6 hours or something.
But they're talking about lots of things. It's not
They are.
just
They are.
Ms. Diagni.
We point you to, and I'm sorry, I don't know if the plaintiff's brief has the time in it too, but we point you to the time sequence and you can go along. And at least the version I have looked at, there is a delay or something between what you see in the screen and the words. So,
But it's figure outable. As long as you've got the timestamps, that's how we have to do the county commission go on for hours. And they talk about the courts just for these 2 minutes. And so we're all jumping to what are they doing? What's our budget? Okay.
and that's that we have both the July 9th meeting, and then that's where they had the hearing, and then they don't vote at that meeting, they vote at the next meeting, and we've got that in the record too, both of them.
Why did they not resolve things in one setting?
That's not what they do.
Okay, so it was on the agenda for discussion and then it comes back for a vote.
That's the way they handle all of their public hearings. They don't vote, then they vote at the next meeting.
Okay. All right. Ms. Flaherty, more you want to tell me about the petition for review, and do you want to talk at all about injunctive relief?
Yes, Your Honor, to both.
Okay.
First, to respond briefly to some of Ms. Main's points. First, to her point that what can still grade, just not exactly here. That's irrelevant because Ravensburger versus Jackson speaks in more general terms than that. And I think the facts of that case are instructive. It was about lactation consultant licenses. And the government maintained throughout that entire case, there was plenty that the lactation consultants could still do without a license. And that included working for the government. And so that's essentially, you can do your entire job just in a different office for a different employer. But the court still thought that the license was interfering with lactation consultants' right to earn a living. So it doesn't have to be a total prohibition in order to violate Ravensburger. And second, to the point of notice for preserving our constitutional claims, Ms. May noted that we didn't represent AWA at the time that we sent that letter.
Yeah.
And that's irrelevant. The standard is simply, were they put on notice that there might be constitutional issues with what they were doing? And the answer to that is simply yes.
This is your letter of July 23rd.
That's correct. And that was the morning of the day that they denied her.
Okay. And the letter is entitled Constitutional Concerns Regarding Potential Denial of the SUP Application. Okay, so your position is notice is notice is notice. Don't matter if we were her lawyers at the time or not. You could be a concerned citizen. You could have been whomever. There's an issue with what just happened here. And now the city council and the mayor is aware.
Exactly. And
Okay.
the city attorney responded to the letter as well.
Okay. Mr. Hyman. All right. What about injunctive relief? How would that work?
The interlocutory injunction?
Yeah.
Action.
Not the deck action, but the injunctive relief, because that's where it got particularly muddy, where you acknowledge in some of your pleadings, look, we know you can't try to get an injunction on an interlocutory basis while waiting for the deck action. That's already been decided. If you're pursuing the deck action the way you are, paragraph 5, but there was this, creative is the wrong word. I don't mean that anyone's stretching any envelope. It's just we're operating in two intersecting spaces because there's a petition for review. And in many ways, your client checks the boxes for an interlocutory injunction about the harm, and the city's going to survive just fine if, while we're working through this, she's able to open up the business that she's already leasing. And so why not It's not quite the status quo, however, because an injunction preserves the status quo, and the status quo is that the permit was denied.
The Green Bull Partners case from the Georgia Supreme Court points out that an injunction doesn't necessarily have to preserve the status quo. It is really more about preserving the case. It's about making sure that bringing the case wasn't pointless to begin with, because we're here fighting over a space and she loses her lease. And that's the Green Bull Partners case that we cite in our briefing.
Okay.
And as to why we asked for the interlocutory injunction, that's what one would normally do when you're seeking relief on a timely basis. But as Your Honor has acknowledged, we've got a lot of new procedures and new law floating around here. And so we wanted to cover all our bases. And the only reason we would need an interlocutory injunction right now is if Your Honor believes that it's not time to decide the petition for review claim. And so the injunction would obviously be unnecessary. The only reason we wanted is if this was going to go on for some time.
Okay. All right. Anything else you want to add?
Your Honor, Ms. Main spoke of the zoning code having more purposes than health and safety. Your Honor noted prosperity.
That was one of the words. I didn't make it up. That's one of the words in there.
Sure.
It was a healthy list, but I thought prosperity, that's a great goal. We all want to be prosperous,
But-
including, I'm sure, Ms. Diagni.
Right, is denying always a permit reasonably necessary to further the prosperity of the city of South Bend? That's what it would have to be under Raffensperger versus Johnson. And it's not. It's reasonably necessary to protect salon products from competition. And the record as a whole, and this goes to the petition for review claim, the record as a whole supports that that was the reason why. It's crystal clear from the entire record. There's nothing in there to support denying her permit for any other reason.
All right. Thank you. Ms. Main, if the way this plays out is that I decide I need more clarity from the city council about why they voted the way they voted. I don't mean each person filing an affidavit, but how about those findings of fact? What's the time frame for that? Because that's a sensitive issue here, how long it would take. If I'm denying the petition, you don't need to worry about findings of fact, and that may spawn other litigation, and we'll work through it. It'd be related, it'd probably come to me. But if I feel like I can't make a meaningful ruling, then that's probably a send back. But my preference would be to send back with a super short fuse. But I also appreciate the separation of powers, and I'm not the city council's boss by any stretch of the imagination. How, in your experience, not necessarily with this municipality, although you may have experience with this municipality, how quickly do those kinds of things get turned around?
Your Honor, I don't know. Because those kinds of things, I've never done that with any other municipality or with this one. I know that and I don't know whether they'd have to do it in a meeting, Your Honor. So I can get the answer to that and let the court know that when I answer the rest of these questions. And by Tuesday. Okay. If that would be okay with the court.
That's the next business day. That's a very reasonable response. So that's fine. That would be helpful to understand. Because if the answer is 90 days, then I do become the city council's boss, and it would be a number less than 90. But I want to see if that's the direction I'm going, what that landscape looks like.
Your Honor, and I will get that answer to you on Tuesday.
Okay. I want to make sure if I have other questions, we've worked through them now, so I don't have to drag you all back here. Is it the case, Ms. Main, as best you understand it, that there is not a separation requirement ordinance on the books in South Fulton, at least not for businesses for which that are classified as beauty salons.
Correct, Your Honor. I don't know if there, remember if there is for any of the other uses, but there is not for beauty salons.
Okay, so it would be a factor that you would be arguing is appropriate for the city council to consider a separation requirement. It's just not one to which a city council member could point, oh, that's 5-103.
There is not an objective separation number in the ordinance.
Okay, got it. All right. I think that's it. Ms. Flaherty, anything else you want to make sure I hear from you and your team?
Yes, I don't think there's any reason to remand for findings of fact and to allow the city council to basically paper over what it's already clear has been done
It
here.
was a risk. I mean, I get that. I know I keep interrupting you, but there is always that risk. And magically, that's what happens with these water bill appeals when you didn't make any findings of fact that the meter was broken. You're just assuming that the meter was broken or wasn't broken. And so they're liable for the bill. And magically, the findings of fact come back and they say, we find that the meter wasn't broken. and then the record is made and they can say, see, this is what we relied on to reach our conclusion that they need to pay the bill or that the permit should be denied.
There's no reason to do that, Your Honor, but if that is what the court does, we ask that you issue the interlocutory injunction so that AWA can get her business started. And the reason that we can do that with the petition for review claim is that we're not proceeding under that constitutional amendment and sovereign immunity wouldn't block it there. We're proceeding under the waiver in chapter 36 of the
What, if it's in the record, answer this question, please. It was somewhere because I read it, I think. Ms. Diagni, she is paying a lease and is ready to roll, but for the permit, or if for some reason there was a revote next week and it was 4-3 in the other direction, she still need to do 6 months of ramp up time before she could open her business.
Oh, no, she'd be able to open immediately.
Okay. So it's the lack of the permit and her belief that a permit is necessary that is preventing her from operating in the space she's paying for.
That's correct.
If I were to go to this shopping center this weekend, and I promise I won't, is there a place that says Awa Braids? Like there's a sign there, but it says closed on it, or it says Fred's Sub Shop because she hasn't painted over it yet because she didn't get her permit.
So it's actually both, Your Honor. She has this Awa Best Grade sign, but the sign for the previous business is also still there. And this is not, and none of this is in the record, but she has been renovating the store to try to set up a jewelry store because she doesn't need a special use permit for that.
As a fallback.
As a fallback.
Okay. All right.
But she could still break in that space.
Right now it's dead space for the city, not great for economic development, just sitting there empty either.
That's correct, Your Honor. And the landlord is eager to get it up and running too.
Although the landlord's getting paid.
Yes, Your Honor.
Okay. But the landlord for the whole mall, I guess, would like to have activity in all of the units rather than just some.
Exactly.
Okay. This is interesting. Ms. Main, normally I give the plaintiff petitioner the final word, but again, you had to come in here on short notice. Not that there was any more notice for plaintiff, but plaintiff filed this action, helped impress upon me the urgency of it, and then all of a sudden, here you are. Anything more you want to add before we wrap up?
No, Your Honor, I will just address, I have a list of things that I was going to address for the court.
Yeah, let's make sure it's a comprehensive list.
So, okay. Cases about separation of uses. And whether Raffensperger overrules by implication.
You don't need to, I'm just asking your thoughts on that. You don't need to respond. I will read it more fully. I became very interested in it once it was cited for two reasons. One, I think it does relate to this case, but two, it's a case that's not about elections. And as I've already said, like, wow, this is great. It has nothing to do with hand counting of ballots or anything. So I was happy for him.
Oh, we're all very happy about that.
Yeah.
And Your Honor, well, if I can't help myself, because I mean, it raises a question for me too.
Sure.
So
You're welcome to opine on that if you want.
if I feel like, yes, and then what would the city council need to do if the court were to send it back?
It's not so much what they need to do is how, if it were sent back because there is an inadequate record, i.e. no findings of fact, how soon do we get those back?
Yes, Your Honor, and that was part of the first thing I have to find out is whether they need to do it at a public meeting or
Yep.
if they need to have a vote or how they need to do it and then the timing of it. Your Honor, that was my list.
Okay, I agree. And obviously whatever you send to Ms. Niles, send to Ms. Flaherty et al.
Yes, Your Honor.
And you're free to respond. No one needs to do fancy briefing. I mean, what is 100% okay is, hey, Ms. Niles, here are 3 cases, and the city council would be able to get findings of fact back to everyone in 19 days. That is P.S. I don't think Raffensperger over. I mean, you do whatever you want with that. That is fine. Doesn't need to be a 9-page letter on fancy letterhead. If you want to do that, that's great. I just want the cases and the answer. And you're free to respond if you say, those are fascinating cases. Here's why they don't apply anymore. Or if you want to do something like that, you're welcome to. It'll just get me heading in a helpful direction. All right. Well, I appreciate everyone being here on a Friday. And I will take this under advisement. I very much appreciate that it is time sensitive for Ms. Diagni. And she is entitled to an answer, whether it's one that brings happiness or disappointment, but at least an answer so she knows which way to pivot, jewelry or braiding, at least temporarily. And then she can chart a different course if the answer is jewelry for now. And we'll take it from there. Thank you, everyone.
Thank you, Your Honor.
And I don't know who all requested the court reporter, but if it's both sides, just make sure you settle up with the court reporter. Thanks.
Thank you, Your Honor.
Brandon, what are we gonna owe you? Or will you bill us?
I believe an email will be sent out.
Okay.
Thank you so much.
All right, let's go on the record, please. And good morning to everyone.
Good morning, Your Honor.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is our Friday, January 19th, 2024 traffic control docket. And I see Mr. Smith is here, so let's take up the Patrick case first. We will be on the record in 2023 TR 790, State of Kansas versus Randy R. Patrick. If counsel would announce appearances, please.
Your Honor, State of Kansas appears by through Assistant County Attorney Paul Egan.
Your Honor, may it please the court, Mr. Patrick appears through Derek Pierce Smith, attorney at law.
And we are here on one count of speeding 77 and a 65. How would your client like to proceed, Mr. Smith?
Judge, at this time, defense would request a breakout room with the prosecutor, if that's possible.
Mr. Dean, would you have a moment to do that? I think we can fit that in today.
Yes.
All right, Missy, if you would help them go into a breakout room, please. we can go back on the record, or if you need to take something else up off the record. No.
Judge,
All right, we are back on the record in 23 TR 790. Mr. Smith?
Judge, defense would respectfully request the court for a motion to continue at this point. I believe my client's having some technical difficulties. I do not see him here. I anticipate journalizing this case before the next court date.
All
I'm
right.
here.
Oh, there you are. Okay.
Where are you? Oh, there he is.
Yeah.
Okay. So,
Yep.
it says Brian Scott,
Yeah.
you're Patrick.
Yes, my phone is labeled wrong.
All right, so the defendant is in person as well as by and through counsel. And Mr. Patrick, are you wanting to set this over another date, did I understand? Or did you?
Mr. Pierce, I didn't get switched to the breakout room, so I don't know the conversation.
All right, well, Mr. Smith, how would you like to proceed then?
If it's all right with the court, I would be requesting a continuance. I can discuss the situation with my client. I anticipate journalizing it before the next court date.
Okay, so Missy, when's our next court date? Another control, it sounds like?
Let's go out not the very next one. We usually do this every 2 weeks. So,
About 30 days then?
yes,
20
you are.
Okay.
And Paul, I have you marked out February 16th. Is that, do you know why?
Probably because we're in a trial.
Okay.
We've only got 3 level ones. Currently set for a week apiece. So,
How about March 1st at 9?
that sounds like a wonderful day.
That sounds fine to me.
All right, so this is continued at the defendant's request to March 1st at 9 a.m., although we may have journal entry of disposition prior to that, if I understood correctly.
Yes, Your Honor.
Yes, sure.
If there's nothing further, we'll.
Well, since I'm
Go ahead.
sorry, Your Honor, since Mr. Smith isn't generally with us on these hearings, I just do a fill in the blank journal entry. I don't have it quite done as far as the case caption showing your client here by Zoom. Yeah, you appeared with him. Continuance request. Thank you.
You're gonna fix my signature now that e-filing's back up.
All right, thank you, sir.
All right, if there's nothing further, Mr. Smith and Mr. Patrick are excused at this time, and we are in recess on this case.
Thank you very much, Judge.
Thank you. Now, we have a bench trial on stipulated facts, I believe, in Gutierrez. I'm not seeing Miss Gutierrez, but maybe she's here. We'll call that case on the record in 2023 FG2 State versus Liliana M. Gutierrez. Paul E. Dean for the state. Miss Gutierrez, are you here?
Your Honor, all of our attempts to contact Mrs. Gutierrez have been returned unsuccessful. So,
Recommendations then, since we are here for trial on stipulated facts following her failure to appear at the last hearing, resulting in a revocation of diversion.
Your Honor, I think at this point in time, the state's going to have to request that a bench warrant be issued.
Looks like we have a B misdemeanor, operating without a license, driving in left, in no passing, and child safety restraint. Does the state recommend any particular bond?
Well, I would have said $500 cash or surety or cash, but given that Miss Gutierrez is in Wichita, perhaps we have a balanced view of
And this was supposed to be for a trial on stipulated facts. Did you?
correct. But
that?
since she's not
Okay.
here,
Okay.
I mean, we can do the stipulated facts, but that's, I think we might as well just issue a bench warrant. I'd ask for a bench warrant amount of $318 cash.
That will be the order of the court. Okay, nothing further. We will be in recess on
Well,
Gutierrez.
and Your Honor, I don't know, I guess since it is a,
We made the findings a violation at the last hearing, so I don't,
right. I guess I could just go ahead and proffer, we issue the bench warrant on property, make a finding guilty and abstention.
but
And have
I
that,
don't typically do that. I usually.
okay. And that's kind of what I thought. So,
Right, so we'll do
yeah,
that.
318 cash.
Okay, and then I think I saw defense counsel, Mr. Geffrey. Who are you representing?
Morning, Judge. Yes, I'm here for Mr. Knox.
Mr. Knox, Dalton Knox. We will take that up next.
Dalton, are you in the Zoom? Are you iPhone? So, Judge, can I have a moment to try and call my client?
That'd be fine. Then we'll
Thank you, Your Honor.
be in recess on Knox. We won't have called that yet. How about, I see James Lawson.
Yes, ma'am.
We are on the record in 2023 TR 769, State of Kansas versus James Omar Richard Lawson. Paul E. Dean for the state, James Lawson in person and pro se. Mr. Lawson, you're charged with speeding 83 and a 65 and driving while suspended. Your first appearance was back July 25th of 2023. You failed to appear at the following hearing September, but you were here with Mr. Paul on the 23rd. So we better wait for Mr. Paul.
Yeah.
Okay, I'm not sure how we got him on this. Oh,
Actually, he's on at 10 o'clock. He's early.
Yes, you're early, sir. Your hearing is set for 10 o'clock.
Okay, my bad. Is there no way we could do this now, or do I have to wait till 10?
No, we could do it early if you can get a hold of your attorney and he's available. Mr. Paul is very accommodating to his clients, but he may have a 9 o'clock that he's tied up in elsewhere. So if you want to call his office and see if he can show up early, we can take it up early. Otherwise, you can either stay on the screen or come back at 10, whichever you prefer.
Okay, all right. I'll come back at 10.
All right, thank you, Mr. Lawson.
I'm sorry about that.
Oh, no problem at all. Who is on the iPhone? I don't, with the,
That's me, Christian Keith.
what was the name again?
Christian Keith.
Correct?
Yes, ma'am.
Okay. Well, let's see if we can take you up here.
Your Honor, I have a notation from my office that Mr. Keith paid the speeding and court costs only, and it shows a balance of $75.
Now, what about the expired tag?
Well,
Let's take that up on the record now. We'll be on the record on 2023 TR 300085, State of Kansas versus Christian W. Keith. Paul E. Dean for the state, Mr. Keith in person and pro se. I'm showing charges of speeding 80 in a 65 and operating a motor vehicle with an expired tag. The tag alleged to have expired in May of 23 and the citation to have occurred November of 2023. And then Mr. Dean, you were saying that something had been maybe paid on this ticket?
the notes are that he paid the speeding citation and court costs. Where they come up with a balance of $75 is beyond me, because the unclassified misdemeanor could obviously carry a fine of up to $500.
Right.
Mr. Keith, generally what I recommend on these is $50 fine. You've already paid the court costs. If you're willing to enter a plea of guilty to that, that will be my recommendation to the court. Pay $50. I would set up for a payer period just to make sure that amount's been paid. At the next, in the next couple of weeks or whenever our next court date is, says like March 1. Okay. As long as you've paid it, confirm, then you don't have to appear during that Zoom hearing.
Okay.
All right, now, Mr. Keith, I don't think I've seen you before. Did you appear one other time?
Yes, ma'am. And then they moved me. I was supposed to get it dealt with there, but then they looked at the record and I had a couple speeding tickets in the past and they went ahead and put me back on this docket. And I think that's where the extra charge is coming from.
Okay, it's not actually an extra charge, but they may have been looking at diverting. Is that what you were looking at, was diversion? All right, well, in any event, let's make sure we get a couple of technicalities that are important ones taken care of. So are you wishing to waive your right to counsel and represent yourself today?
Yes, ma'am.
And no one's making you do that?
Nope.
And you know you have the right to hire an attorney or apply for court appointed if you cannot afford one?
Yes.
All right, so we will have Mr. Dean and Missy, the record reflect both in the journal entry and the docket notes that Mr. Keith has knowingly and voluntarily waived his right to counsel on record. And sir, how do you officially plead to speeding 80 and a 65?
Guilty.
And how do you plead to count 2, operating a motor vehicle on November 18th, 2023 in Greenwood County with an expired tag?
Guilty as well.
Now, as I said a while ago, the ticket alleges that your tag had expired May of 23 and you were stopped November 18th, 2023 for an expired tag. Do you agree with that?
Yes.
And were you driving on Highway 54 here in Greenwood County when the officer stopped you?
Yes.
Okay, and they say approximately milepost 290. You probably don't know what milepost, but do you have any objection to that?
No.
All right, then I will accept. Well, is anyone making you enter your pleas of guilty today?
I'm sorry.
Is anyone making you enter these pleas today?
No, Your Honor.
And do you understand that if I accept these pleas, you're giving up your right to trial and your right to appeal conviction?
Yes.
All right, I accept your pleas and find you guilty. And he's already paid, apparently, Mr. Dean, the scheduled fine and costs for count 1. And you said your recommendation is $50 on count 2?
Yes. And Miss, did you show on your ticket what the scheduled fine was for count 1?
The ticket doesn't show it, but I've got the chart here. 80 and a 65 would be a $75 fine. That could be where the $75 comes from.
That could be.
So your count 1, your fine is 75, count 2 is 50, and your court costs are 108 for a total due of 233, I believe. So how much of that has he paid, Mr. Dean?
Well, Your Honor, it doesn't give me an actual, it says he paid fine for speeding and court costs. So they said, but I don't know. Sir, Mr. Keith, how much did you pay? 108?
You know, I have record of that in my office, and I don't have that currently on me. I paid what was on the physical ticket. I do know it sounds like I paid the balance besides the $50.
Well, where did you see the amount on the ticket? Because I'm not seeing it on the front. Was it on the back?
It was on the very bottom of the ticket. I don't think I have it with me. It's in my office. It was on the back on the bottom, and it was written in.
Back. All right. I don't have the back. I just have the front.
I don't either.
This way, let's order that be paid in full by within 30 days. So you'll have to contact the clerk and pay the balance of whatever you haven't.
Okay.
Or let's have it done by March 1st. Mr. Dean mentioned March 1st. Well, you'll need to have everything paid by March 1st at 9 a.m. or you're going to need to be back here in front of me for a pay or appear date.
How about 11?
11 is even better. We'll do that 11. Now, that may cause you a problem with your journal entry, Mr. Dean, but I'll let you figure all that out.
No, I've got it, Your Honor. Sir, I'm go over this with you real quick. This journal entry has just got the case caption, state versus yourself. Case number has been assigned to it. The date you were here, that you appeared pro se, and that you then waived counsel on the record. I've stricken out in writing because it was orally done. You entered a plea of guilty. Court found you guilty of counts 1 and 2, speeding and expired tag. Court assessed court cost 108, fine 75 for count 1, fine of 50 for count 2. I'm going to change this 30 days to whatever the actual number is to get you to March 1 at 11 a.m. Do you agree that that's what occurred today and that's what the court ordered?
Yes, sir.
So I'm going to put an S/ for your signature and I'll sign here. Thank you.
And then, Mr. Keith, you said you had some information for payment. Do you need the address again for the clerk of the district court or their phone number?
No, I haven't.
All right, that's where you'll need to pay that extra amount of money. And I don't believe there's anything else we need to address. Is there, Mr. Dean?
There's not, Your Honor, to my knowledge.
Okay, Mr. Keith, anything else that we can address for you before I let you go?
No.
All right, then you are excused from these proceedings and we'll be in recess on your case.
Okay, thank you.
You're welcome.
Have a good day, sir.
You too.
Now, is Mr. Knox here yet?
I am not able to locate my client this time, Your Honor, but if we could put the case on the record so I can make some requests to the court.
Very well, we are on the record in 2023 TR 300101. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paul Edie.
Mr. Knox does not appear, but does appear through counsel Nathan Geffrey, Your Honor.
Well, Mr. Knox was to be here today for control on speeding 69 and a 60, DUI, and operating without proof of insurance. I believe he made bond to be here, but Mr. Geffrey, what can you tell us about why he's not here?
Well, Your Honor, Mr. Knox was present at our last hearing. That was for first appearance and also for bond appearance. He did appear at that, and so I do believe that he he does have interest in this case. I've spoken with Mr. Knox in length about the severity of the charges that he's facing. He doesn't believe that this is a joking matter and isn't taking this issue lightly. However, I spoke to him this week. I sent him the link for the Zoom hearing today. He knew that we did discuss that it was at 9:30. Maybe to his detriment, the last hearing was set at 1:30, so maybe he had some confusion about what time he was supposed to be on. I'm not sure, Judge. I'm just kind of grasping at straws here. But Mr. Knox he doesn't have any reason to flee or to not be present here today. While the charges are severe, they are misdemeanors, and so I don't believe that Mr. Knox would have any reason to try and flee or elude the court. It would be my request today, Your Honor, to be able to set this case over. If the court would like to make note in the file that his appearance, obviously would absolutely be mandatory at the next hearing date. That absolutely is understandable, but it would be my request today, Judge, for you to allow me to set this case over briefly. Just even if it's a couple of weeks, just to make sure that he actually is showing up and making appearances. That would be completely understandable, but if we could get a normal continuance request timeline, roughly 30 to 45 days out, just to give us time. We did receive discovery last week, Judge. I just haven't had time to meet with Mr. Knox and go over it in detail. So that'll be our request from the defense today. Thank you, Your Honor.
You're welcome. And I do notice I failed to recite that he also has not only the charges I've mentioned, but it's transporting an open container. Mr. Dean, I find it interesting that he gave the officer a Piedmont address, which is fairly local, but yet he has a driver's license out of Missouri, so I'm not sure what to make of that. What is your position on this request for continuance in light of the failure to appear, Mr. Dean?
Your Honor, I'm not sure what to make of the Missouri driver's license either. I don't know Dalton Knox. I know the family name. I know that they are, my belief is lifetime residents of Greenwood County. Given the fact he has retained counsel, that they have had communications at this point in time, I'm gonna assume that there's been an honest mistake, but I would ask that we just move this over to that March 1 date and make sure he's here, and we can either issue a bench warrant at that point in time and or move forward with trying to resolve the case.
Well, it is highly unusual considering a DUI and a transporting an open container failure to appear that I don't issue a bond forfeiture bench warrant, but in light of everything I've heard from both counsel at this time, I will grant the defendant's request for continuance to March 1st. Missy, at what time?
9 o'clock, if that works for
Is that
everybody.
Yeah, free 9 o'clock? Or would you rather have 10 o'clock?
If I could get 10, Judge, I do have something at 8:30 in Central County.
All right, 10 o'clock it will be. And I know I don't have to tell counsel how lucky his client is today, or fortunate his client is today. All right.
Absolutely, Judge.
If there's nothing further, then we'll be in recess. And Mr. Geffrey, you are excused.
Nothing further from the defense, Judge.
You waived signature. I'm just going to indicate continuance at your request. Time charge the defense and our new date.
Yeah, no, I approve e-signature. That's completely fine.
Thank you.
Thank you, Paul. I appreciate your recommendation.
Yep, no problem. I understand.
Now I see a gentleman, Corey's iPhone, and sir, what is your name? You're Corey Harris, is that right?
Yes, ma'am.
We will be on the record now in 2023 TR 1274, State of Kansas versus Corey Allen Harris. Paul E. Dean for the state. Mr. Harris appears in person and pro se on this one count of driving while suspended. Sir, you had your first appearance December 19th of 23, and we set the case over to today. I'm not sure what our reasoning was, if you were going to apply for diversion or take counsel. But how should we proceed?
Diversion.
I'm sorry?
So I was going to apply for a diversion.
Did you do that?
He did apply for a diversion. Unfortunately, he's not eligible for a diversion. It's
Okay.
been what my office has advised me. So, sir, it appears that you would be able to reinstate your license, probably with a call to Elk County and Wilson County courthouses fairly quickly.
Really?
It's what my certified driving record would indicate to me. So, if you want to take care of this, I would give you an opportunity to move this over to March 1 and see if you can get your license reinstated.
Yes, please.
And, but you need to call today. You need to find out exactly what
Who do
you
I
need
call?
to do. The certified driving record would indicate you need to call the Elk County Courthouse and the Wilson County Courthouse.
Okay.
Wilson County may be nothing more than paying a reinstatement fee, but I don't know. Those are the two courthouses that are indicated that you should contact.
Okay.
Well, all right, Mr. Harris, I will, if you want me to, continue this one more time to let you take care of those matters, but I'm not going to have you come back in the same position and still have not gotten a hold of the other counties and gotten your license reinstated.
Yes, ma'am.
Okay.
I'll get as fast as I can.
Let's see. Let's go a little more than just the standard 30 days, Missy, because how about 60? Of course, if I give him too much, Mr. Dean, he may just say, oh, well, I'll put it off and then not get it done. But
Well, it's probably
I gotta go through today and
indicating is probably more of an appropriate time frame given the speed at which the Department of Revenue motor vehicles works, given their short staff.
How about March 15th, or is that too soon?
maybe a little longer.
Okay. March 29th,
At what time?
9,
9?
9.
All right, Mr. Harris, now I'm going to see you again March 29th at 9 a.m. by Zoom. However, you need to contact Elkin Wilson and stay on that. I suggest you do it even today.
I would do it right after I get off here.
Great. And then don't talk to him and then forget about it for another month. Go ahead and stay on it, okay?
Okay.
All right. Anything else we need to address, Mr. Dean?
I'll address this journal entry right quick with him. Sir, this is a record of what we did today. It indicates the case caption, the case number has been assigned, the date that we appeared, Judge Webster presiding, that you appeared via Zoom pro se. And that at your request, we continued it to the March 29th at 9 a.m. So speedy trial calculations is assessed to you. And I've marked this for pretrial / plea. Do you agree that that's what was done today?
Yep.
Thank you.
All right. If there's nothing further, Mr. Harris, you are excused and will be in recess on your case. Thank you, sir. Now I show a couple more here for our 9 o'clock. Mr. Buchanan, he does not seem to appear. Missy, you don't have anyone else waiting?
No, I do not.
Okay, we'll be on the record in 23 TR3 00083, State of Kansas versus Stephen Wyatt Smith Buchanan. Paul E. Dean for the state. The defendant failing to appear for count 1, speeding 80 in a 65, count 2, operating a motor vehicle without a driver's license, and count 3, operating a motor vehicle without proof of insurance. Mr. Dean, recommendations?
Your Honor, the state did dismiss, apparently, Mr. Buchanan has provided proof of insurance.
Okay.
I see a journal entry dismissing count 3. But that still leaves speeding and no driver's license. So I'll ask for a bench warrant amount of 500 cash.
You said 500 cash?
Yes, Your Honor.
Bench warrant?
Wilson, sorry, he was Wilson County resident, so right across the county line. So I would expect that would be sufficient.
Now, there is a bond or not?
Oh, the bond? I just have I only have a sort of citation in mind.
That's all I have too. But he was supposed to have been here December 19th, and usually we try to have.
So December 19th, Judge Webster, defendant pro se, FFA, his appointment to get licensed to bring in insurance and set it over to this state.
So he may have slipped by without a bond, so.
That's what it appears, Judge.
Try to.
Oh, no, he has a 500, I'm sorry. It did indicate he was to have a 500 OR bond and was to be processed. I can't speak to whether any of that occurred or not.
All right. So bond forfeiture of the 500 OR bench warrant with new bond set at 500 cash or surety. If there's nothing further, we'll be in recess on Buchanan. Okay, the gentleman that just showed up under Zach Parnell, is that your name or are you using someone else's device?
This is my name.
Zach Parnell.
Yes, ma'am.
Thank you. We'll be now on the record in 2023 TR3 00023, State of Kansas versus Jacob R. Derflinger, Paul E. Dean for the state. Defendant failing to appear on count 1, speeding 94 in a 65, and count 2, no proof of insurance. Mr. Dean, recommendations?
Again, with Dorflinger, Your Honor, apparently they took the time to provide insurance, which has been dismissed by my office already based on these notes. So we only have speeding, so I'm going to ask for a 30-day clerk's letter.
Clerk's letter, notice of intent to suspend will be issued. And if there's nothing further, Dorflinger will be, or Dorflinger as it may be pronounced, will be in recess. That concludes the 9 o'clock portion of the docket. And then for our 10 o'clock, we do have, for our 11 o'clock, Mr. Parnell appears early on a diversion control. Are you situated to address that, Mr. Dean, even though it's not set until 11?
I think we can. Apparently, he mailed the paperwork, but we've got it. The issue's been payment.
Let's go on the record then. On the record in 23 TR 803, State of Kansas versus Zachary Parnell, Mr. Paul E. Dean for the state and the defendant in person and pro se. And Mr. Dean, you were saying about his intent to divert.
So he has been approved for diversion. That was, the agreement was sent to him on January 12th. But we need to get the signed diversion paperwork back with payment. Total cost, there's a $100 fee for the diversion, and then $422 is to the centralized court payment center for a total of $522. So, Mr. Parnell, are you on being able to pay that and go ahead and complete this diversion?
I could pay the 100 by next week, but the 522, that's for the fines and everything, right?
422 once you pay the 100.
The 422 is for the fines, right?
Yes.
That would I'd have to do installments on that.
And what are you talking about installments?
Probably 3 to 6 months.
So what I can do is I can give you, if you can send in the $100, I'll give you 120 days to pay the balance. I'll make an amendment to the diversion if you're willing to accept that.
Okay.
Okay. So, Your Honor, I'd ask we set this over to the March 1 date at 11. And, sir, that means that this paperwork and all of these lines that you need to initial and sign on the diversion contract, it's all been highlighted for you, need to be back in our office with the $100, and I will modify. I will put a notation on here that I'm approving that you make monthly payments and have that paid off. The balance of 422 paid off within 120 days. Okay. So, Your Honor, at Mr. Parnell's request, I'd ask we set this for March 1 to make sure we've received the signed agreement and $100 diversion.
All right, Mr. Parnell, at your request, I will continue this to March 1st at 11. You will need to be back here by that time unless the county attorney tells you otherwise. And make sure you do whatever you need to do to get that taken care of, because I won't continue this again, most likely for diversion purposes.
Yes, ma'am. Can that money be sent through the mail, or does it have to be money order?
It can be sent through the mail, but with in a money order or whatever, however you can get the money to the county attorney's office, because that is payable. As it indicates, that is Greenwood County Attorney is who the $100 goes to.
Okay.
And I want to clarify something. Court indicated whether you don't have to appear unless the county attorney's office has told you don't. Well, that doesn't mean we're going to proactively call you if we've received the money and got the signed agreement back. You need to call and check to make sure that that's happened, and that you don't need to appear, that's when the county attorney's office would advise you, you've taken care of that. Now you just need to complete the agreement.
Gotcha.
Okay.
All right. Okay. Anything else we need to address, Mr. Dean?
No, Your Honor, thank you.
You're welcome. Then Mr. Parnell, you are excused at this time as we will be in recess, and you will not need to reappear at the designated time today of 11, because you've come in early and we've been able to address your case.
All right, thank you.
Thank you. All right, Mr. Dean, shall we just kind of close our screens until 10 o'clock?
I think that'd be great, Judge.
All right, thank you.
Good to see everybody back.
Yeah.
Glad you're feeling better. That day well, that's a story. Anyway,
Well, I knew
I've
it had
never
to be
felt so
bad.
just.
Yeah.
My wife was telling me that apparently all I said to she couldn't wake me up. I was so just I had hit the end of my rope, and apparently I had told her all I needed was an extra pair of pants. I have no recollection of any of it.
Well, I'm just glad you're back. I knew it had to be pretty drastic for you to not be available. We were ready to send the officers to check on you.
Well, essentially what I did, Judge, was work myself to death for about 2 weeks in a row trying to get ready for the holidays. And we were doing home remodeling, and I was trying to stay up with court cases and paperwork.
Mm-hmm.
And my body said, you know what? You're not waking up. And
yeah.
It took, I've never felt so disoriented in my life. Come about 1 o'clock, I finally felt like I had my faculties about me again. I've never had that experience, but I guess I can't push myself quite like I used to maybe when I was 42 as opposed to almost 52. So
well, you
lesson learned there.
You still push yourself more than anyone I know. All these homicides and everything you've got coming up, try to find some time to take it easy. Whatever you can do.
Yeah, this is the truth. Man, I just came from a community foundation board meeting with what I did right before we started this Zoom hearing. So, all right, Judge, I'll see you in a few minutes.
All right, see you in a little bit.
Head off, dude.
Who is the gentleman on Samsung SM52360L? You just took your hat off. What's your name? Can you hear me? The guy with the Samsung on his screen and the black shirt, and he just took his white hat off. What's your name if you can hear me? Missy, we must have a failure. Okay.
Yeah, let me try to message him because I don't believe his audio is connected.
Okay, and then we have
Sir, remove your hat.
Well, he heard you. He heard Paul Dean.
Well, he either heard me or he was able to figure out what
he read your book.
Man. I was using.
Yeah,
he's indicating he can't hear.
But he read your body language. Okay.
He got the sign language down of hand to head and lifting up.
Sign language. Okay. All right. Well, we have quite a few people here. Let's see if we could cover any of them. Bailey's iPhone. What's your name? Bailey Stewart?
Yeah.
Okay. Let's look at your case. Let's take your case.
She's a client of, I think a lot of these are going to be represented by Mr. Paul, Your Honor.
All right. The only one that isn't would be Jacob Woods. Did he go diversion by chance? Because that's Mr. Patterson's, and I don't see Mr.
Oh, no. I just got off the phone with Mr. Patterson, Your Honor. He should be logging on. Essentially, he's advised me of what they're doing as far as trying to. He's not diversion eligible.
Okay, so is he going to ask for a continuance?
He's going to ask for a continuance there in the process, and it looks like very close to getting the license reinstated. It's actually a rather unique sanction that's noted on the record that dealing with a claimed vision issue. And they've been dealing with medical, and I think they've just about got that resolved from what Mr. Patterson's told me. He doesn't have a record of convictions. So,
okay.
had quite honestly, had a CDL, which prohibits the diversion, but it has expired and non-renewed. So I believe we will be able to resolve that case once once he has that medical record straightened out with the state.
Okay. So then that leaves us Cortez Grayson. Is there a Cortez Grayson?
There's Mr. Patterson.
All right, Mr. Patterson wants to join us. We'll take up his case. Good morning, Mr. Patterson. And is that Mr. Wood?
Yes, Your Honor.
All right, we'll be on the record in 2023 TR 1019, State of Kansas versus Jacob M. Woods. Please announce appearances.
Your Honor, State of Kansas appears by and through Assistant County Attorney Paul Dean.
Your Honor, Darren Patterson appear on behalf of Jacob Woods. Mr. Woods does appear personally in my office.
And before we went on the record, Mr. Dean was telling me that he's working with you on a resolution and that you may be asking for a continuance to allow that to follow through.
Yes, Your Honor, we would ask for the March 29 court date.
Missy, can we continue this to March 29th at what, 10?
That would be fine.
All right, and that will be granted at the defendant's request without objection by Mr. Dean. Anything else we need to address, gentlemen?
Aaron, I'm just going to I just do this little short fill in the blank. I'm just going to indicate you requested continuance of defense request, time charged to defense, and the new date. Do you waive signature?
Waive signature, thank you.
Thank you, sir.
All right, if there's nothing further then, Mr. Patterson and Mr. Woods are excused and we'll be in recess on this matter.
Thank you, Judge. Have a good day.
Thank you. You as well. Okay, looking again for Cortez Grayson.
We did set that at 9, or did we set that at 10?
10.
10, thank you.
You're welcome. Well, I'll give Mr. Grayson just a few more minutes.
The guy on the Samsung, we still can't hear him. He left and he come back, but he's still not connected to audio. And I've tried chatting with him, but he didn't answer.
Can you not hear me?
Now,
oh, yeah. Now we can. Okay.
What's your name, sir?
Corey McCroy.
Corey McCroy, you are a client of Mr. Paul. Looks like everyone here pretty much is. Let's take an inventory. Have we heard where Mr. Paul is this morning?
Let me check to see if he sent me an email. He and I emailed each other. We're exchanged. I think we essentially have about every case resolved.
He might be hanging over. I think he does. He or his partner do early morning in Sedgwick, I think, or which.
Right. And I think the last, he's had an issue where he's had to cover for his partner. I don't know exactly what the situation is.
Missy, he keeps you up to date on that. Is that what we're doing? He's got the docket over there.
His assistant told me he was in court this morning. That's
okay. So I did get an email from Richard at 9:44, Your Honor. I guess he just said that I think he sent this to yourself as well. He said with the way most cases worked out, should be a quick docket, which I would agree. We think we've reached an agreement on about everything. Just said they'd be running late.
Okay. All right. So we have Daniel Bailey here. Is that right? I'm looking for, or Dale. Dale Bailey, can you hear me? Can you turn on your volume and make sure it's working okay? You see that little red microphone?
I got it.
Okay.
I found it. Yeah.
All right. So now you can put it back on because we know yours is working. Tanisha Daniel.
I'm present.
Okay, we'll put Tanisha Daniel's name in front of her if we can. And you can mute until it's your turn. That's that little red icon, as long as you remember to turn it back on when it's your turn. David Hughes.
Oh, hey.
Where's David Hughes? David Hughes. That's the one you were talking to me about, wasn't it, Missy?
Oh, no, that was Mr. Bailey.
Oh, that was Bailey?
When I was in your,
When you were talking
Yeah.
about Mr. Paul?
yes,
Okay,
Mr. Bailey has a new traffic case.
but he's not here.
Yes, he is. He's here.
Oh, he's the gentleman in the purple. Okay. And David Hughes, are you here? No David Hughes yet.
Your Honor, I'm James Lawson, and I'm wearing purple.
What's your, yes, you're Mr., what was your name again?
Lawson, Lawson, James.
Yes, yes, you're here. Arceli Ibera Morales,
I'm here.
thank you. That's Arceli Ibera Morales, Mr. Lawson, Corey McCroy.
I'm here. Right
Okay,
here.
all right, thank you. Jonathan Salazar Cantu. Jonathan Salazar Cantu. Fails to appear so far. Bailey Stewart is, I'm sure.
Here.
There you are. I saw you. Okay, so Missy, you put Bailey Stewart on there if you want. Isaiah is it Lori or Lowry?
Laurie.
Laurie, you're supposed to be here at 11, but your attorney is Mr. Paw, so we can probably take yours up as soon as he gets here and mix you in with the rest of these for 10 o'clock. Anyone that we haven't addressed that I didn't call? Greenwood County Courthouse, do you have someone on our docket?
There's nobody in that room. I think he just logged in just in case somebody showed up.
Very good. All right, folks. Well, I understand you're all represented by Mr. Paul. Mr. Paul's been talking with the county attorney. I don't know if you've all talked with him, but he'll be with us shortly. Well, I assume shortly when he gets through with his other court commitment, he'll be here and hopefully we'll get you through the process. Okay, thank you all.
Thank you.
And remember, if your phone, if you don't have that little red icon with the line through it, like Mr. Dale Bailey has, if you can see it, I'll be able to hear what you say, or your dog barks, or your cat meows, or whatever. Or so keep that in mind. You may want to click on that. Mr. Dean has done that. Just remember when I call your name to unclick it. So
Your Honor,
yes.
this is Isaiah Laurie. You
Yes.
said my court date wasn't till, my time wasn't till 11. Can I log off and log back in at 11?
Sure, you can do that if you want.
All right, thank you.
You're welcome. The rest of you stay put though. We're ready to begin yet?
Your Honor, I think so. I'm not sure what happened to Richard. I was in the breakout room with him, and all of a sudden I think we got through everything we wanted that he wanted to touch base with me on. And then his screen went to it took him basically all of a sudden he just instantly was out of the breakout room, like he got pushed out, and his screen appears as it is.
Okay. I see we have Attorney Jacob Manbeck. Sir, who are you here for?
Yes, Your Honor, I'm on the Seamster trial, set for 11.
Okay. We haven't started our 10 o'clock yet, but our 10 o'clock can wait since I've waited on it if we get to 11.
Yes, Your Honor.
Missy, do you know where we lost Attorney Paul?
I thought when he come back in, he said he would be right back, but I'm not sure because
Yeah.
he did leave and then he come back. So
Now it's the Massachusetts courtroom, Mike Glasgow, Pam Parker, Sharon Cooper, Jackie Henley. The Duffy case is now in Judge Massachusetts courtroom. The Zero case will be next.
Missy, can you mute his Richards?
So what did he do? Go off to another courtroom again?
Maybe, I'm not sure. His device has been acting weird because I give him an invite to a breakout room and then he disappears like he left, but then all of a sudden he pops up in the breakout room. So I'm not quite sure what's going on.
Cause it just shoved him out immediately. We were talking and it was almost, we were done, but we were still, I could still hear him speaking. All of a sudden he was just out of it. He was gone.
Well, it sounded like the voice on his screen had something to do with maybe calling him to another courtroom.
Yes, it did. I didn't know whether you got the ability to mute him from your location, so we don't have that.
Yeah, Missy.
Yeah, I did.
Let's see, is anybody here for the 11 o'clock such that aren't represented by Mr. Manbeck or Mr. Paul? Michael Brown, any chance you're here early? We have diversion controls for Isaiah Laurie. Is he back? He came in early and then I told him he could leave until 11, so he may not be back till 11. How about Georgette Allen? Do we know if any of these have been granted diversion?
Your Honor, let me get my notes. Oh, here they are.
Is there anything we can do? We ought to go ahead and try to.
Yes, Your Honor.
Some of these.
So Alan has not made contact with our office about the diversion. Deputy shows on the trial we need Deputy Hanson. I don't see him on the screen.
Greenwood County, oh, that's the courthouse.
No, there's Deputy Hanson.
There he
Sorry.
is, ready to go.
Green, we show a balance. Gumfrey, we show a balance.
Okay.
Hozak has not made contact with our office about a diversion, at least at the date this was printed.
Okay.
Lori is now valid on the driver's license, but that's Richard's case.
Oh, that's right.
McGee was mailed paperwork just on January 4th, so I wouldn't expect that necessarily to be back.
What kind of paperwork was that? Was that the application or contract?
Well, let me pull the file. I just said paperwork, so I'm gonna assume if it was mailed, it's the contract we mailed to them. But let me double check. It was the contract that our office mailed McGee on the 4th.
Okay.
Let me see if we've received anything back. I'll let you know when I get an answer to that.
Johnny Hosak, can you come back? Or he just left his screen up.
There he is.
Let's go ahead and take up your case, sir. Did that be all right? You want to unmute and join us? Little red icon with the, looks like kind of like a microphone with the line through it. If you want to click on that.
Who are you talking to? I'm sorry.
To Johnny Hosak.
Okay.
Click that again, sir. If you don't see that little red microphone, do you see the little red line microphone with the line through it? Click it again. It looked like you started to open it, but you clicked too fast. Missy, any thoughts on why he's not able to open that? Apparently he sees it and clicks on it, but it's not opening.
No, that one time it looked like he might have clicked it too fast.
That's
but
what I thought. That's why I thought if he'd click it again, it would have opened.
He may have to leave and come back.
Okay. Well, I just thought, Mr. Hosak, while we were waiting, we could try to take yours up early, but I do need to be able to talk to you. I do see Mr. Richard Paw is back. Mr. Paw, is there anyone we can take up from either the 10 or the 11 o'clock docket? And you're muted, sir.
Sorry, Judge. Ibarra Morales. It's been one of them mornings. I'm sorry.
Oh, that's okay. They do come up. All right, let's go on the record in 2023 TR 879, State of Kansas versus Arceli Ibarra Morales. Please announce appearances.
Your Honor, State of Kansas appeared by and through Assistant County Attorney Paul Dean.
Richard Palm on behalf of Ms. Ibarra Morales, who appears by Zoom.
And how does she wish to proceed today, Mr. Paul?
Judge, we have the lab results back due to lack of evidence. The state's more than likely going to dismiss this DUI. In all candor to the court, I was so focused on that and not the no insurance. She needs to get me her insurance card. She does have one. So I need to present that to Mr. Dean. So, Judge, I just need to set this off one time and we will get it done on the next day.
All right. Now, we've been back and forth with her about whether she needs an interpreter and whether she didn't. And
she doesn't.
Okay.
She doesn't.
I didn't think she did based on her. But
no, she doesn't. She doesn't.
She's not asking for one anymore. Okay.
Nah, we're good.
All right. So you're needing to set this over, if I understood correctly, to get proof of insurance here?
Correct.
Yeah.
I've seen it on the video, but Mr. Dean's office needs to verify that, Judge.
All right. Well, this case has been going on since, through no fault of yours, Mr. Paul, since August 8th.
Well, so, I would say it is my fault, Judge, because I should have had that proof of insurance to Mr. Dean before now.
Well, all right. I'll give you that, but we've had other issues too before you were involved. So
I understand. Well, it looks like we're going to resolve it on our next court date, Your Honor.
Mr. Dean, March 1st.
March 1st is perfectly fine. And just for the record, this is not part of any plea negotiation to some reduced charge in regards to DUI. There was a suspicion of use of illegal substances or some type of maybe a prescribed substance. Didn't necessarily have to be illegal. However, KBI toxicology report indicates no controlled substances whatsoever were present. There was no suspicion of alcohol. No alcohol testing was done. So there is nothing to indicate that she was operating the vehicle under any type of intoxication.
All right.
So I have no evidence to proceed on, so dismiss that.
All right. So that leaves us with insurance and unsafe turning or stopping.
Correct.
Correct.
We'll set those over to March 1st at 10 a.m. So Ms. Ibarra Morales, you'll need to be back here at that date and time as a condition of your existing bond.
What is it? Can you repeat it? March 1st at what time?
10 a.m.
10.
Okay.
And I am not seeing a copy of a bond in the file, but that's probably a computer matter. Mr. Dean, I trust there is a bond, Shirley?
Yes, there's a $1,000 bond.
Okay. All right. Okay, if there's nothing further, Ms. Ibarra Morales is continued at this time, and she's excused and released from these hearings as we will be in recess. Okay. You go. Next, Mr. Paul.
Judge, we will take up Tanisha Daniel.
Will be on the record in 23 TR 961, State of Kansas versus Tanisha Daniel. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paul Dean.
Richard Paul on behalf of Tanisha Daniel, who appears in person by Zoom.
And how does she wish to proceed today?
Judge, pursuant to negotiations, Ms. Daniel does have her restricted license. We have provided proof to the county attorney's office, and they will be amending this to no driver's license in possession, and she will be pleading guilty to that at this time.
What about count 1, speeding, and 89 and a 50, and count 3, insurance? And that's probably a construction zone, I'm guessing, but I'll look at that. Mr. Dean, Mr. Paul?
No, Your Honor, I overlooked this. I did not note. Hold on a second, Your Honor, I apologize.
And I've provided her insurance as well.
Okay.
I think the insurance has already been dismissed, Your Honor. So we were down to 2 counts, the speeding and the driver's license. So it's a plea to the amended charge and dismissal of count 1. This count 3, I think, is the no insurance, which was dismissed with proof.
So you're dismissing count 1, speeding 89 in a 50-mile-per-hour construction zone, and count 3, insurance?
Well, the count 3 is dismissed as proof is provided. So I view it as a 2-count complaint, plea to 1, dismiss 1.
All right. Miss Daniel, how do you plead to driving while suspended?
No driver's license in possession, Your Honor.
Oh, no driver's license in, okay.
That was amended, Judge.
How do you plead to operating a motor vehicle on August 28th, 2023 in Greenwood County, Kansas without a valid driver's license? I'm sorry, I can't hear you, Miss Daniel.
I plead guilty, ma'am. I'm sorry. I lost my voice.
Okay. And is anyone making you enter this plea today by any kind of threats or promises other than this plea agreement?
No, ma'am.
And you understand that you're giving up your right to trial as well as your right to appeal conviction? I'm sorry? I can't.
Yes, sorry.
Okay. And were you doing this driving on Highway 400 around milepost 331 in Greenwood County?
Yes, ma'am, I believe so.
Okay. And it was August 28th, 23?
Yes, ma'am.
I will accept your plea and find you guilty of driving without a driver's license. I will dismiss count 1, speeding 89 in the 50-mile-per-hour construction zone. Count 3, insurance has already been dismissed, so recommendations for sentencing.
30-day controlling sentence, Your Honor. This would be a $100 fine, court cost of $108, $45 booking and processing fee. She has been booked and processed already, and $250 court-appointed counsel fee.
Anything as far as jail sentence, Mr.
30 days suspended for 6 months,
Oh,
non-reporting.
you did say that. I'm sorry.
No problem. And all standard conditions of keep us informed if you change addresses, no law violations, pay all costs and fines within the time period requested or set by.
Anything further, Mr. Paul, before sentence?
No, Your Honor. Thank you.
Okay, Miss Daniel, at this time, you are sentenced to count 2 as amended, no driver's license in possession, to a 30-day jail sentence that will be suspended. You also have a $100 fine, $108 court costs, $45 booking fee, and $250 court-appointed attorney fees. This will be suspended provided you successfully complete a non-reporting 6-month probation. All standard conditions to apply. Do not violate any laws. And how long are you going to need to pay all of this?
I'm gonna need at least a few months, ma'am.
Would 60 days be enough? That'd be about $250 a month.
Yeah, that's fine.
Okay, do you need 90 or is 60 enough?
Can I get 90 just in case, please?
Sure, I'll give you 90 days to pay. Missy, when's her payer appear if we do that?
April 26th at 11.
All right, you'll need to be back here April 26th at 11 if you don't have that paid. If you don't have that paid, your probation can be revoked and you can serve the 30 days. Your license will be suspended again, and you could end up with the collection agent after you get this enforced. So make sure you get that taken care of. Also emphasizing, do not violate any laws. Don't be speeding any speed in a construction zone. That's a violation of your probation. Don't be driving without a valid license, and make sure you have insurance.
Yes,
So
ma'am.
that being said, anything further we need to address, Mr. Dean?
Journal entry, Richard, case caption, transaction code, date we appeared. She appeared via Zoom with you, 4-point counsel, entered plead guilty. Dismiss count 1, plea, count 2, amended to no deal in possession, violation of 244, 30-day, count 3, dismissed with proof, 30-day controlling sentence on 2, 6 months non-report, 108 court costs, $45 booking and processing fee, $250 attorney fees, $100 fine on count 2, conditions of non-report, pay 90 days, pay or appear on April 26th date at 11 a.m. Keep the county attorney's office notified if you change addresses, and no law violations.
Sign it.
Okay. I know the exact amount, please.
Well, your fine is 100. Your court
Judge,
costs-
I believe that comes to 503.
and that's where I was going. That's what I show as the total too, is 503.
Yep. Thank you.
Okay.
You need to call me if you have any questions, okay?
Okay, yes, sir.
And pay that to the clerk of the district court, Greenwood County, Kansas, in Eureka.
Okay, yes, ma'am.
Okay, thank you, Miss Daniels.
Thank you so much.
You're welcome. All right, next, Mr. Paul.
Dale Bailey.
We'll be on the record in 2023 TR 820, State of Kansas versus Dale Bailey, Paulie Dean for the state, Mr. Bailey in person, and by and through counsel Richard Paul. Mr. Bailey, as I understand it, has multiple cases, another traffic as well as a felony. The felony, I understand, Mr. Paul, you're not able to take. Is that right?
That is correct, Judge. And what I would ask for, I know I just got appointed on a case from the appearances on Tuesday. I don't remember when that date was set. I think it was March 1st.
I think Missy has that. Missing?
Yeah, March 1st at 1:30.
And then I would just set this at the same time.
All right, we'll do both of these, Mr. Bailey. March 1st at 1:30. Make sure you are here and available to Mr. Paul.
That's a
Yes,
PHC docket. Do we want to put the two
That's
traffic
fine.
on a traffic docket instead?
Well,
Or-
let's go ahead and keep it on there so it'll track with the felony because we know what usually happens in these things.
Yeah, I will at least keep it there for now. I don't know. It depends on what the felony's got going on. We'll look at it again on March 1st at 1:30.
Sounds great. Thank you, Judge.
You're welcome. Next. Oh, I'm sorry, Mr. Bailey. Questions?
No, Your Honor, I was saying thank you.
You're welcome.
Have a
You
good
may
day.
go, sir. Mr. Paul?
Judge,
We have James Lawson, Corey McCroy.
no, I need to talk to those people first. Bailey Stewart.
Bailey Stewart, we're on the record in 23 TR 997, State of Kansas versus Bailey Stewart, Richard Paul for the defendant, who I believe also appears in person, and Paulie Dean for the state. Mr. Paul.
Yes, Your Honor. I've made a big mistake in this case, Judge. I believe I sent everything to Mr. Dean, but I can't confirm nor deny that now. I've already spoken to to Mr. Dean and to Miss Stewart. I believe she has everything that she has sent to me, and I need to send that to Mr. Dean's office to verify all insurance. And so I'd ask for the March 1st date.
All right, well, first appearance was back in October, and we set it over to December 8th, at which time I was told she was getting really close to reinstatement.
Yeah, and Judge, I think I have the documents in my office, in my inbox.
All right, I will continue this one more time.
Thank you, Judge. I
You're
appreciate
welcome.
that.
And you said March
Can we
1st?
do the March?
Okay.
Can we do that at 10, Missy?
First, 10.
Yes, that'll be fine.
All right, this matter, Ms. Stewart, is continued to March 1st at, you said 10 a.m., Missy?
Yes.
Okay, 10 a.m. You must be back here at that time, Ms. Stewart.
Okay, all right, thank you.
No further contingencies. You're welcome. You may go.
All right.
Judge, let's go ahead and take up Mr. Laurie.
All right, we'll be on the record in 2023 TR1, or I'm sorry, 2023 TR78, State of Kansas versus Isaiah Laurie. Paul E. Dean for the state, Mr. Laurie in person and by and through Richard Paul. Mr. Paul?
Yes, Your Honor. I believe this is our first time up. Mr. Laurie, well, me, I believe. Mr. Laurie does have his license reinstated. However, he has just not gotten proof to me to that yet, and I have not been able to forward that to the county attorney. So it looks like this will resolve at our next hearing. And
Actually,
I would just ask for the March 1st date.
Actually, I believe my office has already verified it.
Oh, they have? Oh, okay. Well, then.
Hold on, let me double check. Yes, he is valid.
Okay.
So this time I'd move to amend. I think it's a safe count. Let me get the file to no driver's license in possession violation of 8-244.
Well, hold on. We've got count 1, speeding 80 and a 65. Count 2, driving while habitual violator, and count 3, no insurance. So what is it you're doing, Mr. Dean?
Your Honor, I take that back. Let me, actually, I'm going to agree on that situation. I need to confirm on insurance, etc. I don't have a notation from my office that we've been able to verify that one way or another if it's been provided to us. So I would ask that we move that to that March 1 date as Mr. Paul just requested.
Well, I'm not happy about continuing it because his first appearance was March of 2023, making this case a year old, and I don't think there's any justification for a traffic case, especially on a habitual violator, to delay a case long enough that they can get reinstated. Reluctantly, I will continue this to that March 1st happy anniversary date, 10 a.m.
Isaiah, call my office Monday, okay?
Okay.
Thank you, Judge. Sorry to anger you.
Gentlemen, I hope we don't make a habit, and I don't think that you're the type that would, but I don't want to make a habit of continuing cases so that habitual violators can finish their 3-year suspension. And
Now, Judge, he had gotten his license back in December.
well, that's still, anyway,
You
go on.
You indulged me last time, and we appreciate it, Your Honor.
All right, we'll move on. Anyone else that we can take up right now?
Well, can we inquire about Salazar Cantu?
Let's see, where did he go? On the record in 23 TR 300064, State of Kansas versus Jonathan Salazar Cantu. Please announce appearances.
Yes.
State Kansas Superior Advisor, Assistant County Attorney.
Okay. Oh, there is Jonathan.
Mr. Cantu, Mr. Salazar Cantu, you are quite late. Your hearing was at 10. I tried to see if you were here several times and you weren't. Where have you been?
I thought it's because I thought my court was at 1, but like I was calling my attorney, but he didn't answer my call yesterday. But that's why I called right now, and they told me it was at 10. And they gave me, they told me to sign, log in.
Well, I was intending to give you a bench warrant for failure to appear. Don't wait till the last minute to call your attorney. Listen to your court instructions, write them down, and be ready to go when your case is called. So, Mr. Paul, do you need time to talk to him since he showed up so late?
Yes, please. Thank you.
All right. All right, so we'll have to set that over. Anybody else before you talk to him that you want to address?
No, because I think I need to talk to everybody else, Your Honor. You can start taking up your 11. Thank you.
All right, thank you. Missy, if you'll take care of Mr. Paul and his clients, we will take up, go on the record in 2023 TR 434, State of Kansas versus Richard Seamster. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paul E. Dean.
And Mr. Manbeck, are you ready to proceed? I lose him?
I'm here, Judge.
All right, so the defendant appears. Richard Seamster, are you here?
He is here, Your Honor. He's actually in my office with me.
Okay, all right.
So he's here.
Okay, so defendant appears in person with counsel Richard Seamster. Mr. Manbeck. Mr. Manbeck, are you still wanting your trial today?
Yes, Judge, I believe so. I had sent a message to Mr. Dean. I'm not sure he's had a chance to look at it quite yet.
Okay, let's give
I
Mr.
think he's
Dean a
pulling the
second
file.
to do that.
Trying to make sure they even provided that file to me.
Uh-oh.
Apologize, Your Honor. Could I have just a moment to contact my office?
Sure. Let's say Jerry Green did not appear. Did Jerry Green sign in?
I have not seen them.
J-E-R-I Green payer appear. How
Yeah.
about David Gumforey payer appear? Is David Gumforey here? I'm not seeing. Okay.
I need to check with the clerk's office to see.
If you have time and can do that, Mr. Dean told me a while ago they hadn't paid, but they could have paid in the last few seconds or minutes, hour.
Your Honor, this is Johnny Hope.
Yeah.
I finally was able to speak on this phone.
Okay,
Can you hear me now?
I can. I need to go back and find you here. You were a diversion control, but I've lost Mr. Dean for the moment. Did you get your diversion application turned in?
Yes, ma'am.
Did you sign your contract?
I contacted them and I contacted them and she said that I could do it Monday and then I just needed to sign some stuff and everything should be fine from there. I just need a little bit more time to go back through with it since I've been working so much.
Okay. We'll need to get Mr. Dean back here, but Missy, we can tentatively look, I think, March 1st at 11, can't we, for diversion review again?
Yes, that's fine.
Thank you.
Okay, Your Honor. Apologize. Apparently they'd emailed me this morning, but I've been either in a meeting or in this court hearing. So I'm going to go pull the ticket out of the copier and I'll be ready to proceed. Sorry.
Okay. And then we'll see if you got your email, Mr. Manbeck.
Hey, Judge.
This has been a most unusual, thank goodness it's unusual docket all morning long.
That does happen.
Yes, it does. So where is your office, Mr. Manbeck? Are you in Wichita or?
No, I am in Iola,
Oh, okay. Iowa.
just east down 54.
I see. It's nice to have you here. And Mr. Paul is back, but we don't have a prosecutor. So Mr. Paul we've got a lot of balls in the air, as the juggler would say.
I'm here, Your Honor.
Okay, so you are here. You have your file or ticket, and did you
Yes.
get a chance to look for Mr. Manbeck's email?
I did not, but I'm assuming I could probably guess, but I based
Well, why don't
upon
you go
the
ahead and
law,
take
I
it
don't
in?
believe I can do anything other than either take a plea as charged or proceed with it.
Well, why don't you take
Proceed
just
with
a
the trial.
minute? Take just a minute if you want to look at that.
It's just a message through Zoom, Mr. Dean.
Oh, okay.
Like a chat or something.
Yeah, that's great.
I wish I could, but I'd be, well, we have our officer here. To my knowledge, I don't have any leeway on that, but.
All right.
Understood.
Thank you.
Are we ready for trial then, Mr. Manbeck? You still wish trial?
Yes, Judge.
All right, Mr. Dean, you have your officer, you said. Are you ready?
Yes, he was on the stairs, Mr. Craig.
All right.
No. Where did our officer go?
He's right there.
I'm here.
Oh, okay. Sorry.
All right, Deputy Craig, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Now, I denied counsel the opportunity to make any opening statements. Do either of you wish to?
No, Judge.
Take waves, Your Honor.
All right, please proceed then, Mr. Dean.
Deputy Craig, would you please state your full name and title for the record?
Rodney Craig, part-time deputy for the Greenwood County Sheriff's Office.
And as part-time deputy for Greenwood County Sheriff's Office, how long have you served in that capacity?
Since I believe April of 2017.
And what type of experience do you have in law enforcement?
I went to the part-time academy. I was a reserve officer for approximately 5.5 years prior to that.
Okay, so there was a reserve officer academy that you completed that course or that training?
Yes.
And during that training, did you also have training in regards to the use of any type of radar device or speed interdiction?
Yes, I was trained. I am not certified. It is not required by our department.
But you are trained in operating a stalker radar device?
Yes.
Is that the type of radar devices that are installed in Greenwood County's patrol vehicles?
We actually have two different types. We have a Raptor and a Stalker. The Raptor is what was in the vehicle that I was driving that day.
And in regards to the Raptor radar device, do you have any particular protocol or habit or custom that you follow prior to deploying that?
Yes. Every morning when just as I go on duty, it does a self-check. And if it is okay, I still use a set of tuning forks to make sure that it is calibrated correctly.
And if it fails sorry?
That is all prior to me ever turning it on to check the speed of anybody.
And if either test has failed, do you take it out of commission at that time until it's been examined?
Yes, if it fails any of them tests, I contact my supervising officer and we get the issue resolved.
So back on May 27th of 2023, what were your duties on that date, sir?
I was patrolling the county. I was on 400 highway during this traffic stop.
And you have occasion to make contact with a 2013 Nissan?
Yes, white in color.
And what drew your attention to this vehicle?
I observed it. What I observed was it was coming out of the passing lane at the 324 mile marker eastbound. It was coming around a vehicle. I observed it to be, in my experience, it looked to me running over the speed limit. I deployed my front facing radar. It indicated that it was running at 86 mile an hour. I turned around and proceeded to make a traffic stop on it.
And what was the posted speed limit in this area 400 where you obtained the reading of 86?
65.
And is that area at 320 at milepost 324, and basically all of the issues that you're testifying to, did they all occur within Greenwood County?
Yes, sir.
So did you have an opportunity to make contact with the driver?
Yes.
And were you able to identify the driver through any type of identification?
Through his driver's license.
And I think at this point in time, I believe Mr. Manbeck, can you perhaps bring your client? I don't believe your client's actually visible. Do you recognize anybody on the screen with us today that appears to be the driver that you cited on May 27th, 2023?
Yes, sir. It is the gentleman sitting there with attorney Jacob Manbeck.
All right, that's the record to reflect that officer has identified Richard Seamaster.
Counsel for the defense has indicated that the person with him is Richard Seamster Jr., so the defendant, and Mr. Craig says that's the person he stopped, so the record will indicate that the witness has identified the defendant herein as the driver.
Side note, I apologize for mispronouncing the last name I see on the ticket, Seamster, but on the notes that were provided to me, somebody put an A between the M and the S. So my apologies for the mispronunciation.
I see.
All right, officer. Was there any conversation that you had with Mr. Seamster after the stop?
I made contact with him. I explained to him the reason for stopping him. Asked him if there was any reason for him to be running that fast. He didn't have any answer for me. Asked him if there was any guns, knives, any drugs of any kind in the vehicle. He indicated no. I returned to my vehicle, wrote the citation, called his license in to make sure that he wasn't wanted for anything. I returned back, presented him with the citation, and concluded my stop.
And again, just for clarity of record, that all occurred, you'd already indicated, in Greenwood County, and that is the same Greenwood County that is in Kansas, correct?
Yes.
Yeah, I don't believe I have anything further at this time.
Mr. Manbeck, cross-examination.
Your Honor, Mr. Craig, you had mentioned that in your testimony that there was another car on the road with the 2013 Nissan. Do you recall what car that was?
I do not recall the color of the car. I do recall that he had just passed that car in the passing lane, coming up to the end of the passing lane.
Okay. And when you said that you locked on with was it the Raptor?
Yes.
When you locked on with the Raptor, can you be absolutely certain that you locked on to the 2013 Nissan?
Yes, sir.
How can you be certain?
It locks on to the fastest moving object.
Okay. Is it a 4-lane? Sorry, sir.
What was the question again?
How can you be absolutely certain that it was locked onto the 2013 Nissan? And you stated that it locks onto the fastest moving object, but you were getting ready to say something else.
It locks onto the fastest moving object. That radar unit is not a dual unit like a lot of other units are. It only locks onto one object. He had just come around the path.
Which one?
Just come around.
Oh, okay. Well, they got
the vehicle.
They got. Oh, okay.
And
thank you.
Hang on. Mr. Paul, could you please mute? I'm picking up some of your conversation, I think. Okay, now, Miss Deputy Craig, you were saying it's not a dual like some units, it only locks on, and then where did you go from there?
It's only a one. It was set up to only lock on to the fastest moving object. The other vehicle was in the right-hand lane, which is for the slower traffic. Mr. Seamster's vehicle was in the left lane and had just come around the other vehicle and was coming out of the passing lane into the 2-lane area instead of 3 lanes.
Say they're on mile marker 324. Can you describe generally that area? Is it 4 lanes of traffic, 2 lanes of traffic? Are there hills?
Actually, yes, sir, there is a hill. He was at the top of the hill. The passing lanes are for the eastbound lane. The westbound lane is a single lane, so there's 3 lanes there. Like I said, the other vehicle was in the right-hand lane, which is for the slower traffic. Your defendant's vehicle was in the left-hand lane, had just come around the other vehicle and was coming into the 2-lane area. It was at the end of the passing lane.
Okay.
Actually, if you would to drive that road is that where I locked onto him was actually approximately the 324.5. But we don't have areas on our citations to put the half mile mark.
I understand that. Was there any cross traffic at that time? So westbound traffic?
No, sir. The westbound traffic was behind me.
It was behind you?
Yes.
So
I was the lead vehicle in about 4 vehicles.
I'm just trying to get my bearings here. So were you in the median or were
No,
you?
sir. I was westbound. And there was about 4 vehicles behind me. I was the lead vehicle in that group of vehicles. When I noticed the white Nissan appeared to be speeding, I turned my radar on, and that's how I determined.
Okay. How close in proximity were you when you turned your radar on? Were you approaching him or were you already past him?
I was approaching.
Okay. And there was another car behind him, right?
Off to his right. Yes.
Okay. So with that Raptor, does it show you an exact indication as to what entity or as to what object it locks onto? Or does it just generally show you a speed?
It shows me a speed.
Okay. So there were 2 cars in your field of view and you locked on to 86.
Yes.
Okay. And you can be absolutely certain that it was a 2013 Nissan, even though it doesn't specifically say with the Raptor which vehicle it's on.
Yes, the Nissan was traveling faster, even by my point of view where I was at. It was moving faster than the other vehicle, and the Raptor picks up on the fastest moving object.
Okay. Is the Raptor rear facing as well?
Yes, sir.
Okay. Is it possible that there was a vehicle approaching you that was going 86?
No, on that Raptor, you have to physically hit a separate button to change from front to rear radar. When I am traveling 400 highway, I always keep my radar on front facing.
Okay. Is that an office policy or is that just your recollection?
That is my policy of my vehicle. We
Okay.
get pretty leeway in how we operate our equipment.
Have you ever forgotten to switch it on to front facing? Ever?
No.
Okay. Judge, could I have just a second with my client?
Certainly, if you want to.
Mr. Craig, have you ever, so is there a gravel road on the south side of 400 where you pulled him over?
Where I pulled him over was approximately 2 miles to the east of where I locked him on the radar. No, there was no gravel road where I pulled him over. There may have been one in close proximity.
Is there one about where you locked radar on him?
Yes.
Okay. Have you ever patrolled or have you ever sat on that road and patrolled?
No.
Okay. Do you keep a log of verifying the Raptor radar, or who keeps that log?
For what log are you
Verifying
speaking?
for verifying the accuracy of the machine.
It is certified every 2 years, I believe.
Okay, when was the last certification?
I don't have I'm not in that vehicle. I'm actually off duty right now. I don't have the exact date, but I know it was within the last year.
Okay. And it's your testimony that you can be 100% certain that my client was going 86 miles an hour and not less than 86 miles an hour.
Yes, sir.
Even if it were.
I trust the radar machine because it is certified and I test it.
One second, Judge.
Someone named Mike is driving. Please do not drive during court. There's too much chance for distraction and danger.
Judge, that's all the questions I have for the officer.
Thank you. Any redirect, Mr. Dean?
Officer, you indicated that you're able to be confident in, based upon your experience and the use of the radar device certified. Does that device give an audible tone as well?
Yes, sir.
So as a vehicle that you're tracking comes closer, kind of like in the old sub movies, that ping comes back to you quicker and quicker and quicker as it's closing the gap.
Actually, it's just a tone, and it is very high pitched when they're moving fast.
All right. So, but that high pitch is basically tracking that vehicle, and if the tone changes as it gets closer, so that you know that this is the vehicle that's approaching you.
Yes, sir.
And visually, what you were observing as far as the two vehicles that were in front of you, Not only do you have the tone and the fact that, and the manner in which the radar device works by locking on to the fastest object, but visually, did that match everything you were seeing? In other words, a vehicle passing another vehicle and it moving faster because of the passing action. Did that match what you observed as far as the vehicle that was locked on, that you say was locked onto and therefore cited for traveling at that speed?
Yes, sir.
I don't have any further questions. Thank you.
Any recross, counsel?
Yes, Your Honor. Officer, mentioning the tone, so when you were approaching and the tone began, how close to Mr. Seamster was that second vehicle?
I'm going to say probably a car length or two behind.
So it was
his.
I'm
Towards
sorry,
his rear.
your voice kind of cut out. Could you answer that again, please?
Approximately maybe 2 car lengths to his rear right side corner.
okay. And so I'm going to call that southwest on the road, right?
Correct.
And you were northeast,
Correct.
right, of both vehicles. Is it possible that that second car sped up?
They had to slow down to be able to merge back into their lane where the passing lane ended, so that your defendant could come on past.
Okay. And then, so you stated that you locked him at 86, but you had also stated it took 2 miles to pull him over. Is that accurate?
When I pulled over to the shoulder to turn around, I had 4 vehicles behind me that I had to let go past before I could turn around. So then I had to catch back up to him.
Okay. When you reapproached the Nissan, did you then lock him again?
No, sir. I already had him locked on. I only have one. It's not a dual radar, as in where I can clock 2 different vehicles or 2 different times. I only had him locked. I had him locked on at 86, and I left that locked on the machine.
Okay. So by the time you got to him, he could have been going a different speed.
Correct.
Okay. I don't think I have anything further, Judge.
Mr. Dean, any further witnesses?
No, Your Honor, state rests.
The state rests. Does the defense wish to present any evidence at this time?
1 second, Judge.
Certainly.
No, Judge.
All right. Does any party wish to make any closing arguments? You don't have to, but I won't deny it either.
Mr. Manbeck's free by closing arguments, Your Honor. Court's heard the evidence. I don't believe there's anything additional I could give, but say that would be of assistance.
Judge, we would just argue that the state's failed to meet its burden, that there were multiple vehicles in the field of view that could have been picked up. That there, the officer testified that he was absolutely certain that no other vehicle could have been picked up. However, there were multiple vehicles in the field of view, and we would just state because of that reason that the state's failed to meet its burden.
Thank you. Well, Mr. Manbeck certainly presented some thought-provoking cross-examination, very good questions, but the court is satisfied beyond a reasonable doubt that the state did meet its burden of showing that the defendant was speeding 86 miles per hour in a 65-mile-per-hour zone. The testimony was clear to the court that the right vehicle was recorded at the right speed. And I won't go back over all of the testimony that supports that because I do feel, as I said, that it was done in a manner to be convincing beyond a reasonable doubt. Finding the defendant guilty of speeding 86 in a 65 does carry or does lead the court to follow the scheduled fine. 86 in a 65 is a $114 fine plus court costs of $108 for a total, I do believe, of $222. The defendant has the right to appeal this decision, as counsel knows, up to 14 days to file that appeal. If the defendant does file an appeal, the appeal bond would be $222 cash. And if the defendant wishes to have some time to pay the fine as opposed to appealing, I can provide that as well. Mr. Manbeck, does your client wish some time to pay that?
Judge, 60 days, please.
All right, 60 days will be granted. Now, in Greenwood County, we usually set a pay or appear date just to make sure that is done. Missy, what would we have for 60 days?
We could put it,
That March 29th date would be slightly over 60.
How about that, Missy, March 29th?
that will work.
All right, counsel, if March 29th at 11 will work, we'll set it there. And of course, if it's paid, no one needs to appear.
Yes, Judge, thank you. That works.
All right, thank you.
I have the journal entry real quick, Your Honor.
Okay, go ahead, Mr. Dean.
We were still trying to fill in. We have a finding. Jacob, I've got the case caption, case number, obviously, the date everybody appeared, your appearance, one count, court ultimately found guilty, court set, or order court cost 108, scheduled fine of 114, 60 days to pay or appear date set, obviously indicating you don't have to appear if it's been paid. Also indicated court gave the notice of appeal rights and set the appeal bond at $222 cash. Have any objection to that?
No, Judge, or no, Mr. Dean, that's fine.
All right, thank you.
All right. Thank you all. Again, if there's nothing further, Mr. Manbeck and client are excused and we are in recess.
Thank you.
Thank you, sir. And Deputy Craig, you're excused as well unless you're here on another trial.
No, ma'am. Thank you.
Thank you, Deputy.
Yep.
All right, I'm going to call the Grayson case, 2023 TR 126, State of Kansas versus Cortez Grayson. County Attorney Paul E. Dean for the state. Mr. Grayson, are you here yet? Mr. Grayson fails to appear, having been ordered to appear at 10. Recommendations from the state.
Your Honor, let me double check on the offense.
Okay.
Speeding and driving while suspended.
After prior.
They did turn in an application for diversion.
I show it's a second. Do you usually grant diversion? And I maybe.
No, I'm assuming that it's been denied. I just opened the file and noted that in here. And usually they put a note on saying not eligible for diversion. That's the reason why when I looked at my notes and then picked up the file, I had a question in my mind about what had occurred. He is a resident of Kansas in Sedgwick County. Y'all asked for, and the prior bond was
Like it was cash or professional surety.
professional bond of $2,500. So Move to revoke the bond. I'm good if I guess I don't have a strong position whether, given we have professional surety, whether the court doesn't want to establish a bond until he's brought before the court, or whether the court wants to double the bond or set some other amount.
At this time, the court will, I'm sorry. At this time, the bond forfeiture is ordered as is a bench warrant with new bond of 5,000 cash or professional surety. And Mr. Paul, did we take up David Hughes?
No, we did not.
How about if we do that? Let's go on the record in
Sure.
23 TR 300082, State of Kansas versus David Hughes. Please announce appearances.
State of Kansas appears by through Assistant County Attorney Paulie Dean.
Mr. Hughes appears by and through counsel Richard Paul. I do not believe he is present.
He wasn't earlier, but David Hughes.
He's called the office and I think he's trying to get on.
Okay. He may have, I have sent him the Zoom link by a Gmail, Judge, and I probably didn't do a follow-up call because Gmail, the first time you send it to someone, it goes directly to their spam.
Okay.
So, if he's trying to get in, Judge, this is just a registration offense. It's not anything overly heinous.
His only charge. His only charge.
It's the only charge.
Yeah.
That's the only one. Judge,
I'm guessing there's a,
since he's having issues,
probably enter a plea on that.
if I could, yeah, I would just, Judge, if he's having issues and he's calling the courthouse, if I could have some time to talk to him, we could set it to the March 1st and get it done that day.
Where does he live? What area? What county?
Iowa.
Mr. Dean, do you object to continuing this to March 1st with an order that he appear at the courthouse?
I don't object. I also don't object if he wants to sign off on a journal entry, enter a plea to this case and get that submitted so we don't even have to come back on a registration plea. We
Perfect. Yep.
Send me
the paperwork, Paul.
We need a controlled date of March 1st. I'll prepare a journal entry for him to sign.
This matter is continued at the defendant's request without objection to March 1st at 10 a.m. He is ordered to appear in person at the courthouse unless it is disposed of otherwise before then.
Thank you, Your Honor.
You're welcome. Being nothing further, we'll be in recess on Hughes. We'll now be on the record in 2023 TR 769, State of Kansas versus James Lawson. Paul E. Dean for the state, Richard Paul for the defendant, James Lawson, who, if he starts his audio and video, appears in person as well. Mr. Lawson's been here, I think, quite a while today. I think you checked in a little. So, Mr. Paul, how does your client wish to proceed at this time?
Judge, pursuant to plea negotiations, Mr. Lawson will plead guilty to driving while suspended. We believe this is the second, and proceed to sentencing.
Your Honor, and I believe that to clarify the record, state would orally move for clarification that the citation that was issued should be amended to reflect a second offense.
Okay. And you said he's going to plead guilty, counsel?
Correct.
And are we dismissing count one, speeding?
Yes, Your Honor.
Yes.
Okay. So, Mr. Lawson, how do you plead to count two, driving while suspended after a prior conviction? James Lawson, can you hear me?
Guilty.
Okay,
Guilty.
so you wish to admit that you were driving while your license was suspended after a prior conviction for the same?
Yes, ma'am. Yes, ma'am.
Okay, is anyone making you enter this plea today by any kind of threats or promises other than your plea agreement?
No, ma'am.
I'm sorry?
No, ma'am.
Okay. Do you understand if I accept your plea, there will be no trial, you will be convicted, and you won't be able to appeal that conviction?
Yes, ma'am.
All right, and you had a prior conviction for driving while suspended?
Yes, ma'am.
And this driving you were doing was in Greenwood County, Kansas on the date alleged?
Yes, ma'am.
I will accept your plea and find you guilty. And recommendations for sentencing?
Your Honor, it asks for a 6-month controlling sentence suspended for 6 months of non-reporting probation. The court assessed a $108 court cost, a $200 fine, a $45 booking and processing fee, and that the court inquire in regards to the ability to repay appointed counsel fee. I believe, based upon a conversation with Mr. Paul, that it'd be appropriate that the 5 days may be served in 2 48-hour blocks, 2 separate 48-hour blocks and a 24-hour block within a 45-day time frame or sooner. And that all other conditions of keeping us notified, paying costs and fines within the time frame established by the court, and appearing at the pay or appear date, all be conditions of probation.
And Mr. Paul, any recommendations further?
Yeah, yes, Your Honor. Judge, he does live in Missouri. He does work 6 days a week for a nursing home. He's going to have to more than likely schedule some time off to do this. Judge, we would ask for about 60 days to make this happen so he can keep his job.
No objection. As long as it's, we just need a pay or appear to be after that 60-day time frame.
Okay, folks, with him being from Missouri and wanting to have all kinds of exceptions to the jail time, I am going to follow the plea agreement for the most part. Mr. Lawson, your fine is $200. Your court costs are $108. Your booking fees are $45. You said you work how many days a week?
6.
He works 6 days a week? Mr. Lawson, is
Yes.
that?
Yes, I do. Yes, I do.
All right. I think you can pay $250 towards your attorney fees, which is the county policy for court appointed, if you can't afford to pay. So let's see what that totals here.
603, Judge.
That's what I'm showing too. So you're going to have a total of $603. You're going to have a controlling term of 6 months in the county jail, but I will grant you probation. Now here's where I'm going to deviate slightly from your agreement. I'm going to order that your probation, because it is a Class A misdemeanor and because it has certain necessities, I'm going to order that that be a 12-month reporting probation. So as soon as this hearing is over, call probation. They can probably work with you by Zoom or by mail or by telephone. Their number, are you ready to write it down?
Give me 1 second. I got a pen and paper right here. What is that phone number?
All right, it's 316. Oh,
Judge.
Go ahead,
Okay.
Missy. If
Sorry.
you give me the number, I was trying to give you the wrong county.
Okay. It will be Jessica Morgan, and her phone number is 316-452-4320.
Now, I don't know if she'll be available during the lunch hour, and I see it is now 12 o'clock or thereabout. But you call her as soon as she's out. If she doesn't answer at noon, or shortly after this hearing, then you keep calling her this afternoon until you get through, or at least leave her a message. So it's 12 months reporting probation. And how much time do you think you need to come up with that $603, or do you?
I can do $100 to $120 a month.
Okay, I'm gonna order that you pay $100 a month. When can you make your first payment?
In 2 weeks.
Okay. What is 2 weeks from today?
January.
January
2nd.
February 2nd. I'm gonna give you till February 15th to make your first payment, but then each payment thereafter of $100 will be due on the 15th of each month. Make sure it's paid. And what about the jail time? You said, your attorney said you need some time to set that up. How much time do you need?
Like 60 days would be at minimum, but I can work with it. I can do 2 48 hours and then a 124 hour. That would, because I would have to tell my boss that she's gonna have to hire somebody and then to cover my 6 days a week. And so letting her get that time to get somebody, she won't be as mad at me and I can keep my job better.
Okay. Well, what I will do is say that you must begin your first 48 hours within 60 days. And the 3 weekends must be consecutive, one after the other. So I'll give you 60 days to start it, but you better have it set up 1, 2, 3 in a row afterwards. Do you understand what I'm saying, Mr. Lawson?
So every weekend I need to go 2 days in a week or a day.
And I'm going to give you up to 60 days to get it started. But once you start it, it's going to be 3 weekends in a row.
Yes, ma'am. That will be fine. That sounds perfect. I thank you for the respect.
Now, I think it makes sense. I don't know how you're getting to and from work legally, but one of your conditions is probation. Will be that you violate no laws and that you follow all standard conditions. Once you get that jail time.
Is there a way to possibly, serve it here in town? Possibly
Serve it what?
in town?
No, you'll have to serve it in Greenwood County unless you can. Yeah, I'm just going to leave it at that. You have to serve it in Greenwood County. Once you get all your money paid and your jail sentence served, I will consider restoring that to non-reporting probation. But so that might give you some incentive to get that paid a little quicker if you can.
Oh, yeah, I will. Thank you, Judge.
You're welcome. And I'm really tempted to make it a condition of probation that you get your license reinstated, but rather than make that a condition, I'll just make that a strong recommendation for your benefit.
I will. It's the only thing is I'm the only one working in my home currently. My wife just got out of the hospital. I know this is no excuse for the law. I understand that. I'm just saying she's getting a job now. And so the time that you're giving me, it would be perfect for her to get a job. And then, that's really it. I'm the only one working and it's just timing and driving up there.
Well, you can't drive. That's another inconvenience. You have to find somebody to drive, because if you drive, you can get your probation revoked and you may serve 6 months in the Greenwood County Jail. All right.
No,
I'm sorry. Go ahead.
My drives. I'm sorry. I didn't mean drive.
None at all.
He didn't mean he was driving, Judge. He just means driving up.
Okay. All right. If there's nothing further, then we'll be in recess, and Mr. Lawson is excused at this time.
Thank you.
You're welcome. We will now.
Hey, Judge, you want to take up Mr. Hughes real quick since he's on here, even though we've reset his reset his,
Oh, we
court
came
date?
back? Sure. We'll be back on the record in 23 TR 300082, State of Kansas versus David Hughes, Paul E. Dean for the state, defendant now in person, over 2 hours late and with counsel. Mr. Hughes, where are you? There you are. Well, now he's muted. David Hughes, can you unmute? You know what I mean? Click on that little red icon that looks like a microphone. See that little red microphone with line through it? Can you
Is that it?
That's
Yeah.
it. Okay. Mr. Hughes, it sounds like the attorneys are trying to work something out on your behalf. And we've continued this to March 1st at 10 a.m. Is that correct, counsel?
Yes, Your Honor.
So I'm also ordering that you appear at the courthouse next hearing, Mr. Hughes, if you and your attorney do not have this figured out and resolved by that date, you'll need to be at the courthouse itself.
March 1st?
Yes, at 10 a.m.
David, I want you to call my office Monday morning, okay?
Okay. Monday morning, your office?
All right.
That number is?
Call my office, 316.
316?
303.
303?
0100.
0100.
Yep. Thank you. Judge, that's all I have for him.
Okay, thank you, Mr. Paul. Thank you, Mr. Hughes. Mr. Hughes is excused.
Paul.
You may log off at this time. Oh, go ahead, Mr. Dean.
Thank you, Your Honor. Mr. Lawson, case number, date we were all here, plead guilty. Guilty to count 2, count 1 dismissed, modified date, excuse me, not amended, but just say 262 amended to a second offense. That's how it was an amendment. 6-month controlling sentence on count 2, suspended for 5 days in jail, 12 months, reporting probation, 108 court costs, $45 booking and processing fee. Oh, I forgot. I was filling out other parts of it when the court assessed attorney fees of $250. Assessed attorney fees of $250, fine of $200. Change the journal entry up to indicate conditions of probation include pay all costs and fines on a payment schedule of $100 per month. Payment by the 15th of each month, first being due 2/15/2024 is what that all says there. Serve the 5 days in the Greenwood County Jail. The first 48-hour block to be served within 60 days of today's date, followed by 2 successive weekends of a 48-hour jail sanction and a 24-hour jail sanction. No law violations. Court granted state's motion to amend to count 2 to a second offense. Upon payment of all costs and fines and jail service, the court will consider modifying probation to non-reporting.
Now, gentlemen, that was David Hughes that we just took up, correct? But right before or right after Lawson?
Yeah.
Then
that's the same picture. That looks like the same picture of him. It's just a older one, much older one.
The gentleman,
I think
the blue teeth and fangs in front of the crucifix, that's the David Hughes that was just here?
I believe
looks
so.
Looks like a screen picture that he.
Yeah, it's just a screenshot.
All right, so is he still with us? It's not a different David Hughes. Missy, do you want to just help him leave then if that's the same David Hughes?
Was everybody good with that journal entry?
I am, Mr. Paul.
Yeah, I'm good.
Okay.
Yes.
All right. Well, I was confused that maybe we had 2 different David Hugheses, but I didn't see but one on the list. All right, let's move on to McCroy. Again, Missy, if you want to help David Hughes leave. We're on the record in 2022 TR 491, State of Kansas versus Corey McRoy. Paul E. Dean for the state, defendant Corey McRoy in person, and with Richard Paul. Mr. McRoy is another one that's been running late, but he is here. So how do we want to proceed, Mr. Paul?
Judge, this is Mr. McRoy's second driving while suspended after talking with the prosecutor. Mr. McRoy is going to plead guilty to that charge, and then we will proceed to recommendations for sentencing.
All right, Mr. McCroy, you have one count of driving while suspended after a prior conviction, a Class A misdemeanor with mandatory minimum 5 days in jail. How do you wish to plead to that charge?
I'm just gonna plead guilty to it.
You're admitting that you did drive while suspended in Greenwood County, Kansas on the date alleged?
Yeah, I didn't.
That's all you need to say. Yes.
Okay,
Sorry.
and you had a prior conviction for driving while suspended?
That's what Richard said.
And you don't doubt that? You think that's true?
Yeah, I guess. I mean, it's been a while. I haven't really drove that much in the last few years, to be honest with you. And the times that I did, I guess apparently the time that I did, I got in trouble. So.
Well, I don't want you guessing, or I want
Yeah,
you to be confident.
I'd say that's probably true.
Probably true. All right.
Yes,
well, you're not
true.
Denying it. Okay.
Your Honor, if it assists him for the record, he was convicted May 21st, 2021. Driving while suspended, and in any event, I could dig back further to get to the actual county, but
All right.
no,
So
it's been a couple of years.
I'm sorry, Mr. Paul, what'd you say?
We would stipulate that this is his second.
All right. And that this did happen within the statute of limitations in Greenwood County, Kansas?
Yes, Your Honor.
All right. I will. Is anyone making you enter this plea, Mr. McCrory?
No.
Okay. All right. And if I didn't ask you, I'll ask you again. If I did, you're giving up, you're giving up your right to trial, and you will be convicted.
Yeah.
All right. I will find you guilty of driving while suspended after prior conviction. Mr. Dean, recommendations?
Your Honor, 6 month sentence, suspended, 6 months non-reporting, 108 court costs, $45 booking processing fee. Court appointed counsel fee if the court believes that's appropriate. Court establish a payer peer time frame. Keep us notified. Conditions non-reporting, keep us notified of any and all changes of address. Payer peer as directed, and no law violations. Service of the 5 days of Greenwood County Jail. I don't think we discussed that, so I don't have as far as a time frame on when that 5 days needs to be started. I'd leave that to court's discretion because I don't have a particular recommendation.
Mr. Paul, anything further before sentence?
Yes, Judge. Mr. McRoy would like to schedule in his jail time. I don't think he has any objection doing the 5 days. He just needs a couple of days to kind of get some things in order. Is that true, Corey?
Yeah. Yep.
Okay, so Judge, honestly, I just asked him to report to the Greenwood County Jail by 5 o'clock Monday. That'll give him a couple of days, a weekend to get everything in order. Then I don't have anything further.
I think that's January 22nd. All right, Mr.
Yes.
Thank you. Mr. McCroy, where do you work?
I'm not working right now. I just honestly, I've been in Oxford sober living and Bel Air, and I'm supposed to be going out to 90 days intensive outpatient at Desert Hope in Vegas. But I had to wrap up my Wilson County probation and my Elk County probation last week. They let me off probation. Both counties did, and so now I'm just had to get this taken care of so I can go on to Desert Hope or figure out what what was going to happen here. So I didn't have no idea what was going to happen. So I'm not working right now.
What kind of work do you do when you're working?
Lawn and gardening.
Your fine is $200, your court costs are 108, and your booking fee is 45. I believe that totals about 353. Your controlling sentence will be 6 months in the Greenwood County Jail. The minimum must be served of 5 days, starting Monday, January 22nd at 5 p.m. You have to turn yourself in by then. I'm going to put you on a 12-month reporting probation initially to make sure you get everything paid, to make sure you serve your 5 days, to make sure you violate no laws, do not use any drugs or alcohol, follow all standard conditions. Now, you mentioned several treatments locally and then going out to Las Vegas, did you say?
Yeah.
Yes.
Well, it's an
Okay.
intensive outpatient. It's after you go to inpatient, and
I cannot imagine taking a drug and alcohol issue to Las Vegas for treatment, but talk to your probation officer about that.
yeah, it's
That
the
just sounds like
professionals.
a recipe for disaster, but that's between you and your probation officer. Anything else we need to address?
Or waive attorney fees, is that correct, Your Honor?
Yes, we did.
Okay. No, I nothing further from the state.
All right, then you may go, Mr. McCroy, but call your probation officer. You have a pen or pencil?
Yep.
Good for you. 3-1, Missy, why don't you give it to him?
Okay, your probation officer will be Carrie Seeley, and her number is 620-953-2013.
Again, I don't know if she's at lunch as it's 12:15, but it's your responsibility to call her today.
All right, thank you.
You're welcome.
Richard. Case caption date, we're all here, pled guilty. Count one, second offense, 6 months, 12 months report, 108, booking processing, 45, waived court appointed counsel fee, $200 fine. Conditions of probation, keeps notified. Served the 5 days. And I also just marked all special and standard conditions of probation because it'll be in the contract that the court already enumerated. Starts 5-day jail January 22nd, 2024 at 5 p.m.
Sign it.
Is that am I able to get off the probation if I serve my 5 days and
And pay
my
that?
fine?
Well, what I will probably do is transfer it to non-reporting for the balance of the year.
All right.
But that's a good question. Thank you for asking it. Anything else you'd like to ask?
That, and I do believe, Your Honor, that if he's in treatment, that probation will probably work with him in regards to reporting, not in person, but
right
via Zoom, phone, etc.
Yeah.
Okay. If there's nothing further, we'll be in recess, and Mr. McCroy is excused. You may go, sir.
Thank you.
You're
Good
welcome.
luck, Corey.
Yep. Thank you.
Okay, I don't have it checked, but I thought Mr. Salazar can too, that we dealt with him, did we? I don't have any notes of that.
No,
Okay.
he's here.
All right, let's
He
go on.
started to, Your Honor.
We're on the record in 2023 TR 300064, State of Kansas versus Jonathan Salazar Cantu. Please announce appearances.
Your Honor, State of Kansas, appears by Assistant County Attorney Pauline D.
Richard Paul on behalf of Mr. Salazar Cantu appears in person by Zoom at separate location of the council.
All right, and how does he wish to proceed today, Mr.
Judge, pursuant to plea negotiations, Judge, state will dismiss the no driver's license in possession. Will plead no contest to transporting the open container. Suspended, the recommendation is going to be a suspended sentence, non-reporting probation, $100 fine, and costs.
And I also neglected to add in there, Richard, or Mr. Paul, that I think the court needs to suspend him for 30 days or the state will hit him for 90.
Say that again.
I believe the court I believe the court also needs to suspend him for 30 days or the state will suspend him for 90 on a TOC.
Okay.
Is my recollection.
Okay, well, that would be smaller than if it was no driver's license, so I would agree that's the way to go.
Okay, where is Mr. Jonathan Salazar Cantu?
Yes,
Right
ma'am.
there, Judge.
There you are. Okay. All right. So I understand that the only charge that he's going to plead to is transporting an open container.
Correct.
All right. And how do you plead to transporting an open container of alcohol in Greenwood County, Kansas?
Guilty. I know I shouldn't let other people be drinking on the car.
What kind of alcohol were you transporting?
It was a Corona bottle
And
that the other guys were drinking.
And it was open and you partially drank it?
No, not me. The other, it was
The other guy. Okay, you're
Yeah, his
passing.
passenger's in the car, Judge. He was operating the vehicle.
Okay, and do you remember approximately when this would have occurred?
No, I don't remember.
Sometime in 2023?
Yes, it was like 3 months ago, around there, 2 months.
Okay. And do you remember what highway you were on or street?
It was the 54 highway.
54 in Greenwood County? All right. Do you understand you're giving up your right to trial? You'll be convicted and you won't be able to appeal that conviction if I accept this plea? Okay. And is anyone making you enter this plea today?
No.
All right, at this time, I do accept your plea and find you guilty of transporting an open container. Are you employed, sir?
No, not right now.
Okay. And did you go through the booking process? Did they take your fingerprints at the county jail on your picture?
Yeah, they took pictures, fingerprints, and everything.
Okay.
Your Honor, and that's confirmed through the transaction code sheet and the ticket also is marked booked.
All right. And why aren't you working, Mr. Salazar?
I work on roofing, and right now the company that my boss doesn't have work.
Okay.
Because of the cold.
All right, I'm going to waive your court-appointed attorney fees. And counsel, you said you recommended $100 fine?
Actually, I believe on TOC.
Not more than 200, and I didn't know if you did.
It's a first offense, Your Honor. I show no record, so yes, $100 fine, court cost, court wait, court booking processing fee of $45.
And not more than 6 months in jail or both fine and jail. Did you recommend any jail time?
Given lack of record, Your Honor, I recommend 60 days. Controlling, suspended for 6 months, not reporting.
Okay. Anything further, Mr. Paul, before I pronounce sentence?
No, Your Honor. Thank you.
You're welcome. All right. So, Mr. Salazar, you're going to have to pay a $100 fine, $108 in court costs, and a $45 booking fee. I believe that totals about $253. You don't have to pay for your court-appointed attorney.
I have a question right now.
Yes?
Would that $253 they would take it out of my bond money because I paid $5,000?
Oh, yeah, he paid a cash bond, Judge.
We can take that out of your cash bond and then they can return the rest to you.
Okay.
Perfect.
And then 60 days controlling jail sentence. If you don't want to serve that 60 days, make sure that they get that applied to your account, that 253 at the clerk's office, and make sure you do not violate any laws during 6 months.
Okay.
And as long as you do that, make sure that's paid and don't violate any laws.
What number? I'm sorry. What number do I have to call?
I'm sorry?
What number do I have to call for the clerk's office, my honor?
The clerk's office, Missy, can you give that to him?
Yes, the clerk's office is 620-583-8153.
Okay, thank you.
And I'm going to order that for 30 days, you do not drive. Your license is considered suspended by the court for the next 30 days, so don't drive.
Okay.
Apparently you have a valid driver's license?
Not right now.
Oh, you don't have? Okay. All right, well, those are the orders of the court. Anything further?
No, Your Honor, thank you.
No,
Okay.
it's the journal entry.
Right, go ahead, Mr. Dean.
All right. Case name, date we all appeared, enter plea guilty.
Yep.
Dismiss count 1, guilty count 2, 60 days, 60 days to pay, 108, court cost, $100 fine, waived court appointed counsel fee. Again, 60 days to pay. We didn't set a pay or appear date, and also notify the county attorney's office of the condition of probation, the law violations. And I just put a notation that all costs and fines will be paid out of the cash bond that's been purchased.
Yeah, sounds good.
All right, thank you.
You see, we only need probably our next court date since it's going to be, the bond's going to be applied.
Okay.
March 1.
Yep, March 1 at 11.
Okay.
And Jonathan, if they've already sent you that check back, you won't have to come back, okay?
Oh, okay.
Okay, if you've got your refund and they've taken out the payment, you don't have to come back at that date, okay?
Okay, yeah, it's because like it's the bond I paid 5,000, so they'll take it out of there.
Yeah, they'll take it out of that and send you a check for the rest. Call my office if you have questions, okay?
Okay.
All right, thank you.
Can I have your number? Because I don't have it right now. Richard, sorry.
316 303 0100.
Okay.
Good luck, Jonathan.
Thank you. Appreciate it.
All right, Judge.
Before we go any further, there's a Michael Brown. I thought I told him not to be in a moving vehicle a while ago. He still is.
I'm sorry. I was a passenger. I didn't know that was against the rules.
Well, it is. So let's make sure that, because it's too easy to distract a driver if you're trying to do Zoom court, it's too dangerous. So
No problem.
let's take your case up. We'll be on the record in 23 TR 300062, State of Kansas versus Michael S. Brown, Paul E. Dean for the state, Michael Brown in person and pro se. Mr. Brown is here on speeding 75 in a 50-mile-per-hour construction zone on October 15th of 2023. Mr. Brown, you're set for trial. Are you still wishing to have your bench trial today?
Yes, ma'am.
All right. Are you do you have a CDL?
No, ma'am.
All right. There is a program called Diversion. I don't know if you were interested in that. I don't know if you qualify for that. That would be between you and the state. But I just want to make sure you are aware that if you did qualify, some counties won't divert a construction zone. I think Greenwood has, but once trial starts, it's too late for pre-trial diversion application. And I bring this up, I see Deputy Hanson is here and ready to go. It may be too late already for pre-trial if you are interested in that, but is there any discussion that needs to take place between that, Mr. Dean and Mr. Brown?
I'm not sure. I'm sorry. Go ahead, sir.
I don't see any notation that he was advised of diversion. It's my understanding generally at first appearance that occurs. This is the first time I've seen this case. Based upon the motor vehicle report, he would be eligible. Sir, do you recall any discussion with you regarding the diversion program?
No, sir. I don't know what that is.
Okay, the diversion program essentially gives a first-time offender the opportunity to apply for a diversion, which, as I've told you, you are qualified because I have a certified driving record from Oklahoma that indicates that you have no prior history of any type. Therefore, if you took a diversion, you would pay the court costs and fine, and there is a $100 fee that's added to it. So there's an expense, but essentially it's just an agreement between your office or between my office and yourself. That you'll comply with the law, you'll pay those court costs and fines and the diversion fee, and generally we monitor you for 6 months to make sure you've not had any other issues. And at the end of the 6 months, if you've complied with all the terms of the diversion program, which I kind of covered most of them for a speeding offense, the case is then dismissed. Therefore, it should keep your record from having any convictions, which generally helps with insurance and other issues dealing with licensing. Now, I say that, I think sometimes insurance companies go do searches and try to find people electronically. So, but still, I think it's a program that's a benefit to most people who want to keep their record intact.
Understood. Yeah, I don't think so, sir. I appreciate the opportunity and the explanation of that.
Very good, Your Honor. I'm ready to proceed. I'd waive opening statements.
Okay, any opening statements from you, Mr. Brown?
Yes, ma'am.
Okay. Now, first of all, let's make sure that car is stopped, right?
Yes, ma'am. I can show you.
Okay,
I'm not
fine.
moving.
Okay, go ahead now. Your opening statement, please.
Yeah, I'm not an attorney and I don't claim to be one, but on the day that this happened, I'm not exactly sure what the date was. I was traveling eastbound on 400 in Greenwood County on a 2-lane road. I was being tailgated by a larger farm type truck vehicle. And then I entered into what appeared to be after I was pulled over, was identified I was in a construction zone, though there was no active work, nor were there any evidence of construction. And I did not notice that it was a posted construction zone, only that there were pylons off in the grass next to the median. Upon the officer pulling me over, they're pulled over both vehicles onto the side of the road into the gravel. The officer mentioned to me that he did notice that I did have a larger vehicle up behind me, and I did acknowledge that. Honestly, ma'am, I don't know exactly how fast I was going, but I did check with the state of Kansas and their highway construction. And on the date of that fine, they did not register an active construction zone. Now, I don't know what that means one way or the other. But that's what my recollection of the day was. And I'm just praying upon relief here that with the circumstances, it wasn't an active construction zone that I could ascertain. I was being tailgated.
Okay, now, sir, you're starting to repeat, and that's okay, other than this is your statement as to what you believe the evidence will show. So that is what you intend to show the court as your evidence today. Is that correct?
Yes, ma'am. I'll stop.
No, that's okay. I just want to make sure you understood that that's what an opening statement was. So
thank you.
If there is anything else you want to include in your statement, go ahead and do that, or you can wait till your evidentiary portion, whichever you prefer.
I'm good. I will close my statement.
All right. Mr. Dean, please call your first witness.
State calls Deputy Hanson.
Deputy Hanson, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Dean, please proceed.
Deputy Hanson, would you please state your name and position, title for the record?
My name is Clinton Hanson, and I'm a deputy sheriff for the Greenwood County Sheriff's Office.
How long have you held that position?
Since June 19th of 2023.
And prior to that, had you been a certified law enforcement officer?
Yes, sir.
And how long have you been a certified law enforcement officer?
13 years.
And through those 13 years, have you been trained and or certified and or both in regards to use of radar devices in regards to speed interdiction?
Yes, sir.
And when were you, when did you obtain any certification or training in regards to those matters?
I've received training at the Kansas Law Enforcement Training Center and every department that I have worked at.
So you've been trained on this device for the last 13 years, correct?
Yes, sir.
And on the date in question, what were your duties?
That particular day, my duties were just general patrol.
And were you patrolling US Highway 400 in Greenwood County, Kansas?
I was, sir.
And on October 15th of 2023, did you have occasion to make contact with a 2020 Palisade Hyundai?
Yes, sir.
And what is it that drew your attention to that vehicle?
As I was traveling westbound on 400 highway in the posted construction zone, I observed two vehicles approaching me that appeared to be going above the posted speed limit. At that particular occasion, when I saw them, it was a slight downgrade, which is how I was able to see both vehicles. I activated my patrol unit's radar and it gave me a reading of 75 miles an hour. As I proceeded, the area in general itself kind of comes to a V. So as I was going down one hill, so were they. And when we met, the Palisade in front was still registering at 75 miles per hour.
And how far, so this was posted, where was the postings for this construction zone in relation to the vehicle, the Palisade?
I would say we were probably halfway inside of the construction zone total, and it's about a 3-mile area.
And do you agree that, was there any active construction going on at the time?
No, sir, it was a Sunday afternoon.
And, but it was still posted as
Yes,
a construction zone. And I take it had speed reduction signs also posted?
On both entrances and throughout.
And the posted sign within the construction zone was what speed limit?
50 miles an hour.
And is this construction zone and your observance of the Palisade traveling 75 all within Greenwood County, Kansas?
Yes, sir.
And in regards to the use of your radar device, do you have any particular habit or custom for prior to deploying that device in the field?
I do, sir.
And what is that?
Even before I go 10-8 or in service to start my shift, I test my radar using the issued tuning forks with it. And then I also perform its own self-test functions.
And if it fails any of those tests, you then, what do you do?
If it fails any of those functions, I do not use it. It's not something I can readily take out of my vehicle. So I just simply don't use it. And I notify my command staff to address the issue and make corrections.
And on that date, back on October, 15th of 2023, I take it if you were deployed on a device that it passed all of its self checks and external checks?
Yes, sir.
After you obtained that reading, did you make contact with the operator of the vehicle?
Yes, sir. After that vehicle passed, I also noted that the vehicle behind it was traveling at the same speed. I then slowed down and maneuvered safely so I could turn around and stopped both vehicles.
And the Palisade operator, were you able to identify that individual through any type of a driver's license?
Through an Oklahoma driver's license.
And does that driver's license of the person you encountered, do you see that individual here today?
Yes, sir.
And how are they identified?
It is the white male listed under Mike.
Your Honor, I'd ask for the record to reflect that Officer Hanson, Deputy Hanson, has identified the defendant, Michael Braun.
The record shall so reflect.
At that time, did you issue Mr. Braun a citation?
Yes, sir.
And did you, was there any conversation with Mr. Braun about what had occurred?
I did tell him that as he passed me, I noticed that the vehicle behind him seemed to be following too closely. But both vehicles gave me the same reading as we were passing. Based upon my training and experience, that tells me that both vehicles were in fact doing the same speed.
I don't believe I have any further evidence. Thank you. Or any further questions.
All right, Mr. Brown, this is not a chance to make statements, but you can certainly ask questions of Deputy Hanson. Please feel free to do so.
Deputy Hanson, how far was the vehicle behind me when you observed it?
I cannot give you an exact distance, sir.
But you did feel that it was in a pressing matter, that you did feel that you needed to make a comment, that you did observe that it was behind me in a tailgating manner?
I don't know if it was a pressing matter, but I did note that, and I did tell you that it seemed
And
closely.
Was the other driver issued a citation?
Yes, sir.
And in regard to the posting of a construction zone on a state highway in Kansas, do you know what the law says as to how and where those postings must be placed and displayed?
I do not, sir.
So you cannot state today whether those were posted correctly or incorrectly at the day that you gave me a ticket.
Relevance, Your Honor.
Okay.
He's asking the officer to draw some legal conclusions, and that's for the court to decide, not the officer.
Okay, I'll rephrase my question.
If you would, please.
Did you personally see the eastbound construction posting on Highway 400 on the date that you gave me an infraction for speeding?
I am 100% sure that I did, sir, as I traveled up and down that road many a time.
Then you saw it that day.
I'm sorry?
And you noticed it that day that we're discussing. You were traveling westbound on that highway.
Yes, sir. I travel that highway pretty much every day that I'm working.
Okay, but did you travel specifically westbound in that construction zone prior to issuing me a citation?
I do not recall if I did or not. I feel it's reasonable.
So you can't, understood. So you can't state that that sign was where it was supposed to be on the date that you wrote me a ticket, as it should be by Kansas law to identify a driver that there was an active construction zone.
Sir, the best answer I can give you to that is I am
It's
not.
yes or no.
No, well, okay. Go ahead, Mr. Deputy. Answer the question. Mr. Dean can always follow up if he feels the need to.
Okay. Then I guess no.
Okay. And back to the type of what type of radar are you using?
It is called a stalker dual.
So does that radar have the ability to pick up multiple vehicles at one time or just one vehicle?
It depends on how it's operated by the operator.
And how was it being operated the day that you witnessed me?
I typically have it with the fast mode on. So what that means is it will pick up the strongest target and the fastest target.
Okay, so typically is not how was it being operated the date of that we are talking about. How was it at that time?
I cannot recall, sir, to be 100% direct with you.
So what are the differences in the types of operation of the radar?
The difference is if the fast mode is on, it will pick up the fastest vehicle as well as the strongest vehicle. If that mode is not on, it will just pick up the strongest signal.
And what determines a strong versus a weak signal?
That is something that you would have to ask the makers at Stalker. That is mechanical and engineering beyond my knowledge.
So is it possible that you were on a downhill slant and I was on a downhill slant, and that the radar in use could have not been turned on to the fast mode, and that it picked up on a much larger vehicle that was traveling at the same rate or greater speed that I was traveling at? Is that possible? Yes or no?
I'm sorry. Can you repeat the question? I got a little confused there.
Is it possible that at the rate of speed you were traveling and at the rate of speed that you presumed that the oncoming traffic was traveling, and at the incline that you were traveling, as you mentioned in your testimony, that you were traveling downhill, the oncoming traffic was traveling downhill. So your radar possibly not being in the set that it's typically set in, that you said that you were not aware of how it was that day. could it have picked up on a larger vehicle traveling at the same or greater speed? Yes or no?
I will say that it's possible.
So yes, it is possible. So in saying that that is possible, you cannot say then 100% certainty that the 2020 Palisade that you presume to be exceeding the speed limit was the vehicle that was locked on by your radar.
Incorrect, sir.
So explain to me, if it was not on the fast mode, how you know that the vehicle that it was locked on was the Palisade versus another vehicle.
Because I waited until we were on the same level. Therefore, the vehicle in front would be the strongest signal, and that is the one that I locked on.
So you're saying that when you first locked on, you're not sure how fast the vehicle was going, correct? Or which vehicle you were locked on.
Okay, I if I may, sir, I believe we may have a little bit different terminology here. I began tracking both vehicles as they came approaching me. I did not hit the button to lock the radar onto screen until we were on the same level and I knew which one was the vehicle in front of me.
Well, let me ask that, because I think earlier you said, and court can correct me if I'm wrong, was that you engaged the radar initially and then you re-engaged radar as you got closer. Is that not what was stated?
I activated it as I saw both vehicles approaching me, but then there's a separate button to actually lock that speed onto the radar screen.
So if you lock the speed, it still doesn't know which vehicle it's actively locked on. So when you locked on initially, it locks then, correct?
When I push the button.
Okay, when did you push the button?
As we were both on the what I would call the same level. As you were coming back up and I was going down, therefore the vehicle in front of me is the strongest speed, and I know which vehicle it is at that point.
So if I understand correctly, you made a visual observation of two vehicles that were coming down a hill, and that made you turn your radar on, and then it said that there was a vehicle going 75 miles an hour, but you weren't sure which vehicle until later.
Correct.
So how much time passed between the time that you got a speed reading and the time that you hit the lock button?
I don't know the exact time. I'd probably say 5 to 10 seconds.
And how far away would you say you were when you observed the oncoming vehicles?
Quarter to half mile.
Okay. Go. That's all I have for now.
All right, any redirect, Mr. Dean?
I believe Deputy Hanson, through the questioning on Tross, gave all the answers that I would have been looking to solicit once clarifications were made. Therefore, no.
Any further evidence, Mr. Dean?
State rest.
All right. Does the defense have any evidence it wishes to present? I was told you would with your opening.
The evidence was in my cross, Judge. And that I have my wife as a witness, if she would like to attest to the comments and the conversation that was had, that the officer did, state that I was being
Well,
pressured.
hold on. Do you want to testify? Do you want to call a witness? You don't have to, but you can if you want.
No, I'm good.
You don't want to testify and you don't want to call your wife?
Oh, I've testified. Have I not already? I don't need to have a witness.
You were not under oath. So do you want to take it?
Yes, ma'am. Yes, I would like to
Raise
testify.
your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, please proceed.
I'm testifying that on the date in question that I do not feel that I was exceeding the speed limit, that I was being tailgated, and that the radar that was used was not identifying my vehicle. I do not feel that it was an active construction zone. I don't feel that the state has provided evidence that they were in witness that it was an active construction zone. And that is the end of my testimony.
Okay. So that was more argument than testimony, but any other witnesses you, well, let me ask you, Mr. Dean, cross-examination.
No.
Okay. Any other evidence or witnesses you wish to call, Mr. Brown?
No, ma'am.
All right, both parties resting, and I think I've heard basically the defendant's argument as his opening statement and through the brief testimony he gave. So I think I'm clear on his position as well as the state's position. During his cross-examination, Mr. Brown asked the witness if he was 100% certain, or could he answer within 100% certainty? Well, that is not the test in these cases. It's proof not within 100% certainty, but proof beyond a reasonable doubt. And the court is satisfied that the state has met its burden in that regard as far as showing that this was a construction zone. Under Kansas law, the workers don't have to be present in the construction zone, but it has to be marked, and this was indicated through the testimony, and the court is satisfied beyond a reasonable doubt that it was marked with cones and signs. And the court is satisfied that this officer did observe consistently with what his radar showed, that this defendant was going 75 in a 50-mile construction zone. Finding the defendant guilty, the fine for 75 and a, I'm sorry, yeah, 75 and a 50.
What's that?
Okay, who am I hearing speaking?
I'm sorry, my wife was on
Okay.
something.
The speed for 75 in a 50. Again, the schedule normally is normally 150, but that is doubled because of the construction zone. So the fine would be $300 and court costs are $108 for a total due of $408. And I can give the defendant time to pay. You do have up to 14 days to file your notice of appeal with the Kansas Court of Appeals. If you do so appeal, your bond will be set at $408 cash. Do you need some time to pay this, Mr. Brown? I can give that to you.
I do not.
All right. Will you be paying that in person, or will you need to mail that, since your looks like your address is not in Eureka where the courthouse is? So how about if I just give you 30 days to get that mailed in, or do you want to deliver it in person?
I'm going to explore with counsel my options on appeal.
All right, well, I'm going to order that you have that paid within 30 days or appear. Missy, what's our 30-day approximate 30-day pay or appear?
It'll be that March 1st at 11.
All right, so you either need to have this paid by March 1st at 11, or appear in front of me at that time, or have your notice of appeal filed with your appeal bond of $408 within 14 days. If you don't have this paid, then your license or your appeal perfected, you can have your license suspended and a collection agent after you and things like that. So anything else we need to address, Mr. Dean? You have a journal entry to address?
Finish the journal entry.
Okay. While he's working on the journal entry, any questions that I can answer for Mr. Brown?
Yes, ma'am. Who at the county or the prosecutor's office handles your FOIA request?
Well, Mr. Dean, do you want to answer that? It'd probably be through the, no, go ahead.
Depends on what he's requesting. There's multiple elected offices. If it's something the county attorney's office maintains, it'd be the county attorney. If it's something dealing with the Greenwood County Sheriff's Office, I would direct that to the Greenwood County Sheriff. If it's something in regards to the overall County, then I direct that to the Greenwood County Clerk, not the Greenwood County Clerk of the Court, because that's separate agency altogether. So those would be the entities that you would be contacting.
Perfect. Thank you.
All right.
You're welcome, sir.
All right, so we'll give Mr. Dean just a moment to prepare the paperwork and go from there.
Okay. I think I've got everything now. Your Honor, I've added a couple additional advisories just because Mr. Brown indicated he wanted to speak with counsel, which is his absolute right regarding the notice of appeal. So I've given him a little further information in regards to that. Sir, this is what journal entry, basically it's a record of what the court found today. It's got the case caption, the case number, indicating it was a journal entry of trial, and that we were here on this date, that you appeared via Zoom, pro se, that there was, it did mark out that there was no waiver of counsel, because actually a traffic infraction is not one of our counsels, where you're eligible for court appointed counsel. So there wasn't an inquiry as to whether or not you wanted counsel. Court found you ultimately, I have not marked it, guilty on count 1. Proceeded to sentencing, and ordered you to pay court costs of $108. We're also assessed a $300 fine. Then I put down here at the bottom, I'm just going to try to read it to you in this fashion. Appeal rights given to appeal within 14 days in writing to the Court of Appeals, because the judge is a licensed attorney. If she was not a licensed attorney, it'd be appealed to the clerk or to the district court. Notice to be filed, though, in the Greenwood County Clerk of the Court's office. That's where the appeal process starts. There's then a docketing statement that goes to the Court of Appeals. There are other time frames on that. That's who you should consult with your own private attorney for further information on that perfection process. Do you agree that that's what the court found today? Not saying that you agree with the court's findings, but just simply that's what the court found and ordered.
Yes, sir.
Thank you. I will mark your signature as an S/ and then it will be filed in record.
All right.
I'll be able to get that copy of that to you, and any attorney could also request that be forwarded to them as well.
Great.
Okay. There's
The
nothing.
first of the 14 days does start tomorrow, and it does include weekends and legal holidays, unless the last of the 14 days is a weekend or legal holiday.
Gotcha. Thank you.
Okay.
You're welcome.
Thank you, Mr. Brown. Thank you, Mr. Dean and Deputy Hanson. At this time, Mr. Brown and Deputy Hanson are excused from these proceedings unless, Deputy Hanson, you're here on subpoena for something else. Then you have to stay.
Oh, ma'am, thank you.
You're welcome. We'll now be on the record in 2023 TR 381, State of Kansas versus Rebecca Stewart. Paul Dean for the state, Richard Paul for the defendant. Rebecca Stewart, did she not appear today?
No, Your Honor.
She was supposed to be here on her third or subsequent conviction for driving while suspended and no insurance dating back to May 19th, 2023. Recommendations from the state, Mr. Dean?
Your Honor, I guess at this point in time, I don't have anything to request other than a bench.
Mr. Paul, anything you can share with us?
Yeah, Judge, we have a resolution to the case. We have a proposed journal entry. I spoke to my client last week and she was going to enter in that and we were going to do it on the record today. She has been in good contact. I don't know what has happened today, Judge. So, Judge, I would ask for a continuance. I know that the state has asked for a bench warrant, but that's my position.
Well, she's got a long history in this case. Her first appearance was back May 23rd, and we've had it continued to, looks like July 7th at the defendant's request, October 13th. She was here smoking, drinking Dr. Pepper, eating, smacking her fingers, and had the attitude, quote, "I have to take care of myself," end quote, when her demeanor was addressed, but it was set over to December 8th. And she was reportedly working on getting her license reinstated, really close. And it was continued without objection to today. She was continued on her bond, which looks like it was set in May for reduced, the bond was reduced from 5,000 to 300 cash, I'm sorry, 3,000 cash or surety. So
Thomas Taylor is the bondsman on it, Your Honor. There is a professional surety.
say that again, please. I didn't hear you.
There is a. Oh.
Yeah, there's a professional
My
surety.
little green deal around wasn't lighting up when I was talking. There is a professional surety on that bond, Thomas Taylor.
3,000.
Yes.
Okay. So recommendations, Mr. Dean, what did you say? I'm sorry.
Your Honor, I'd requested a bench warrant. I guess at this point in time, I'm still going to make the request for the bench warrant, but I would stay I'd stay basically issuing it until Monday at 5. Give him Mr. Paul's contact.
Well, if the defendant showed more respect for the court, I'd be more inclined. At this point, I am going to issue bond forfeiture bench warrant. New bond set at 3,000 cash or surety, but I will stay the execution of the bond. You said Monday at 5?
Yes, Your Honor.
And if she shows up, what do you propose we do to handle that, Mr. Dean? Because our next
you better plead.
Oh,
hey, Judge, here would be my solution. If I can get a hold of her and get her in my office, we have a journal entry. I would just have her sign it and submit it to the court by e-file.
What does this journal entry propose? Since she's been driving while suspended, this would be at least her third.
Judge, the
$300 fine, court costs, attorney fees, booking fee, 12 months probation, possible early termination if no law violations and she's able to reinstate while on probation.
Because count one's going to be dismissed, Judge.
Yeah, and $300 fine, court costs, attorney fees, and control sentence.
You're saying you would dismiss a third time driving while suspended that carries a mandatory minimum 90 days up to a year? Did I hear that right?
Yes.
Dismissing that for the no proof of insurance, yes, Your Honor. Which is also going to suspend her license.
Well, my order will stand. See if she shows up Monday.
Thank you, Judge.
You're welcome. Well, now
That's my last case. Might be excused.
Oh, I suppose we'll excuse you, Mr. Paul.
Well, I'll see you about 1 whenever
About
we get
30 minutes if I get done by then.
Yeah, correct. Thank you, Judge.
All right, thank you. We'll now be on the record in 23 TR 300110, State of Kansas versus Georgette Allen. Paul E. Dean for the state. Georgette Allen is here in person. Miss Allen, you are going to apply for diversion, and I understand you have not contacted the county attorney about doing so.
Correct. Well, I've contacted them. I got the application, and I am off of work next Friday to turn it in with the fees.
Did you not understand that you were supposed to have that taken care of by today, your court date?
I did not.
Well, I don't know how I can make that stuff any more clear. You know, I don't have to grant a continuance.
That's what we were hearing.
Now who's talking? Now who's talking?
I think that was just background.
Somebody else there in your vehicle with you?
I'm not in the vehicle. I'm at work.
Someone there at work with you trying to talk for you?
No.
Okay. Well, okay. So, Miss Allen, you did not apply for diversion. You're thinking about doing that in the near future. So you're expecting me to set your court date over another day to let you do that. Did I get all that right?
Yes, ma'am.
Now, if I set this over to another day, are you gonna come in here and do the same thing and say, well, I didn't know that I had to have it done?
No.
All right. So but you have, where'd you get your application?
They emailed it to me.
Okay, somebody at the county attorney's office, when did they email it?
The week after I went to court.
Okay, so you've had that quite a while. Mr. Dean, what have you to say about all this?
So you say you have the money,
I
which is
don't
the
right
$100, but you will win
by
You said you're
Friday.
by Friday, and you're gonna take it in, so Friday of next week is what you're saying?
Yes, sir.
You're gonna take the diversion fees and the diversion application in. You know, I guess I won't oppose the March 1, but I'll just note on the journal entry, Your Honor, that the diversion has to have been applied for. And those fees, everything has to have been paid.
Okay, Miss Allen, I'm going to continue this to March 1 at 11, but if you want diversion, you better have it signed, paid for, and filed by then, because I think you probably know I'm not going to grant you another continuance to apply for diversion, right?
Yes, ma'am.
Okay. All right. So at this time, if there's nothing further, Mr. Dean, do we need to do anything further with the journal entry?
Now I'm not quite done. I just got the case caption, the number. I'm going to show that you appeared pro se, which is without counsel. I'm going to mark on there, this is being recorded and transmitted. So if there's something show up different, that you and I both appeared, Judge Webster presiding, and that at your request, so therefore speedy trial time was calculated against you. It was moved over to March 1st at 11 for diversion control. Also note that your application, everything has to have been submitted. And in the end, if I look at your record, it would appear that you're eligible. I don't see any other convictions. In any event, do you waive signing or approval of the journal entry and signing the same? That way,
Yes,
I can
sir.
get it on file. All right, thank you.
All right, thank you. You are excused at this time, Miss Allen, and we'll be in recess on your matter.
Thank you.
You're welcome. Thank you. We'll now be on the record in 23 FG 300004. State of Kansas versus Johnny Hosack. Paul E. Dean for the state. Mr. Hosack appears in person. Can you hear me and talk to me now, Mr. Hosack?
Yes, ma'am.
All right, you're in that same position. You were supposed to contact the county attorney about diversion and didn't. So what's your situation today?
I did contact her. We've been swamped overtime and I kind of lost track of the days. I contacted her and she told me that to go ahead and do this today. And then if everything went through, follow back up with her Monday morning and she will line me out with all the paperwork and give me started from there.
And when you say she and her, who do you refer to?
Ma'am, I didn't catch her name. It's the number that you gave me to call.
So you called us after court at your last court date, but you haven't turned in the application yet, right?
Correct.
And when
she could set it. I'm sorry.
If we set this over like we did the last one, you think you can get it applied for? And then if they approve it, you think you can get your contract and payment back?
Yes, ma'am.
You look like you're at work there. What kind of work do you do?
We work on train cars.
Okay. Well, that sounds like you're probably a pretty responsible person normally, so I'm really kind of surprised you haven't taken care of this better. Although you told me you've been busy, but Mr. Dean, your thoughts about continuing this to March 11th under the same circumstances we did the last one?
I'm agreeable, Your Honor.
All right, that's what we'll do then. If you get this diverted, they may not make you come back, so you may not have to see me or hear me grumble anymore if you get this taken care of. So, Mr. Dean, anything further? You want to talk to him about the journal entry or anything before we let him go?
Sir, just like we did in the last case, I just got the caption filled out. I'm just going to indicate you appeared without an attorney, that I appeared, judge presided. You asked for a continuance. We sent it over to March 1 at 11. Excuse me, March 1 at 11 for diversion control, that you need to have applied and paid for and got your diversion contract signed and the fees paid by that court date if you want to proceed with the diversion. Would you agree to waive signing as we did in the last case?
Yes, sir.
Thank you, sir.
Okay, then you may go, sir. Thank you.
Thank you.
You're welcome. We'll now be on the record in 23 TR 300096, State of Kansas versus Toric McGee. Paul E. Dean for the state, Toric McGee failing to appear on a diversion review. I understand that, are you here, Toric McGee? No? I understand from what you told me, or somewhere I heard this, Mr. Dean, that your office mailed the contract, the actual contract, January 4th. Is that right?
That's correct, Your Honor.
And you haven't received it back?
That's correct, Your Honor.
How do you want to proceed, sir?
Let's see how quick she got this to us. Your Honor, it does appear that she's showed up to all the courts. I see she's been approved, so she doesn't have a record. She is a Missouri resident, resides in Springfield. I note that I'm going to ask that we set it over to the March 1 date. I would note that there's been a lot of severe weather and that the post office hasn't been moving exactly quick to begin with. And I would hate to have a bench worn out for somebody and we get their paperwork signed with the money in it on Monday. Just because of our location.
Sure. Continued to March 1 at 11. Missy, that day is probably getting pretty small, isn't it?
It is, but we could probably put another one on there.
Okay. If they want to hear their diversion, that'll help.
That was McGee?
Yes, Toric McGee. Will now be on the record in 2023 TR 300043, State versus Olivia Wilson. Paul Dean for the state. Miss Wilson. Okay, you were going to apply for diversion. Did you do it?
Yeah, it should be coming in the mail.
Well, it was supposed to be taken care of before today, so let's take this a little more seriously. What do you mean it should be coming in the mail? What should be coming in the mail?
The diversion. I sent it in the mail last week.
The week before court, you sent in the diversion application or the diversion contract?
The application.
Have you, from the other defendants, gotten the impression that this is supposed to be taken care of before today, not just applied for in the mail? Do you understand that?
Yeah, but it was difficult with getting the paper and then trying to submit it.
What difficulties did you have?
The paper, it got lost, so then I had to get another one.
I'm going to set this over to March 1 at 11, but I would strongly suggest if you want diversion, you have it paid for and filed by then, because I am probably not going to give you another continuance.
Ms. Wilson, are you currently 18?
No, I'm 17.
Okay. I just happened to notice through here, we have a notification of peer parent legal guardian.
You live with your parents?
Yes, I do.
You go to school?
Yes, I'm at school currently.
Okay. High school or college?
High school.
Okay. Mr. Dean, any objections setting it over to March 1st at 11?
No. Ms. Wilson, just try to get a hold of my office, and if you're eligible for a diversion, just make sure you get the contract and everything back, submitted back, so that we can take care of this. It'll all be concluded on March 1, okay?
All right, and can I get that case number again?
Yes, it's GW 2023.
2023.
And then TR, it's just two capital letters, T and an R. And then 300043.
All right, thank you.
All right. There's nothing further. Ms. Wilson is excused to get back to class. Thank you, Ms. Wilson. And we'll be on the record in 2023 TR 791, State of Kansas versus Jerry Green. Paul E. Dean for the state. Jerry Green fails to appear. Missy, did you make one last check to see if Jerry Green had paid?
I checked with our office here and neither one of them had paid, Green or Gumphrey, but that doesn't mean they didn't send it to Topeka and we haven't got notification of that yet.
Well, while we're at it, we're also on the record in 2023 TR 392, State versus David Gumphrey, Paulie Dean for the state, and the defendant failing to appear on a pay or appear, either pay or appear. And we don't have any record they've paid. We don't have any evidence that they're appearing, but as Missy pointed out, it's possible, remotely possible, but possible they could have paid in some fashion other than through the clerk of the district.
And Gerald Green was CDL, had hired Shannon Cooper. So I'm kind of be surprised if that wasn't paid in some fashion, but hey.
What have we been doing with those, Mr. Dean? It seems like we had developed a system to continue them or something, or?
Yeah, I tell you what, I'm going to note in this case, just because we can't fully communicate still with the Topeka, that we set a notice. I mean, they didn't appear. I'm just going to mark them failed to appear, and that if I think both of these are well, Mr. Gumphrey, I'm going to say that we need a bench warrant for him, $500 cash if he has not paid, because he was a driving while suspended. Gerald Green was a speeding citation, wasn't eligible for diversion due to CDL, that a 30 days clerk's letter be forwarded if we can't confirm that these payments have been made.
As I recall, the clerk's letters, what they're telling me in the Butler County office is that the clerk's letters it may take them a long time to process with the computer system as it is, but I don't know. I keep hearing it's back, it's working. Sometimes it does, sometimes it doesn't.
I thought we were all supposed to be back up and running at this point in time.
So I think your recommendations are well founded and will be the order of the court in both cases. Now, I think that covers the docket, the 9 o'clock, 10 o'clock, and 11 o'clock sections. Anything else, Mr. Dean, are missing?
No, are we ready to start our next court docket? It seems like this has gone on that long.
Well,
yeah, we are. We got 10 minutes.
I bet no, our next traffic docket.
Oh,
yeah.
It does feel like that too. But yeah, our PHC starts in 10 minutes.
Yeah, well, I hope everybody can get a little bite to eat before the next hearing. I actually got to go check my calendar. I've got lost track what I'm supposed to do next.
Yeah, you could have been doing court somewhere else 20 minutes ago. I hope not.
Well, it is what it is. I'll get there as fast as I can. Now that this is